Monday, June 20th. Kat, could you please read the roll? Here.
Arthur,
Here.
Smith,
Yes.
Silent,
Present.
Berardi,
Here.
Poinsett,
Here.
Sangre.
Here. Okay, our first order of business is minutes of June 6th. Are there any comments?
I would move to approve the minutes of the June 6th meeting as submitted.
Second.
Thank you. Kat, could you poll us, please?
Shearer,
Yes.
Arthur,
Yes.
Smith,
Yes.
Silent,
Yes.
Berardi,
Yes.
Poinsett,
Yes.
Sangre.
Abstain. Okay, we move on to findings for AP 22-02, 499-22-0000303-3, a request for a hearing appealing staff's tentative decision approving type 2 tree application number 499-22-0000303 tree to remove a 15-inch Norway spruce and a 50-inch Doug fir for the construction of a new single-family dwelling on the site. The site is located at 19175 Pilkington Road, 21E 19BA 02900. The staff coordinator on this was Daphne Sissel, Associate Planning. Any comments on the findings?
Move to approve.
Second the motion.
Thank you. Kat?
Shearer,
Yes.
Arthur,
Yes.
Smith,
Yes.
Silent,
Abstain.
Berardi,
Yes.
Poinsett,
Yes.
Sangre.
Yes. Okay, thank you.
Yeah,
Yes, sir.
I'll change my vote to no on that. I did vote no on that.
Oh, okay, thank you, Craig. Okay, now we're going to move to our public hearing. The public hearing is on LU 220024, a request for a major variance and a modification to an approved partition, number LU 20-0038, to eliminate a condition of approval requiring flaglot screening fences along the side property lines. This site is located at 1880 Twin Points Road, designated 21E09BD02712. The staff coordinator is Ellen Davis, Associate Planner. We have adopted consolidated hearing outlines for
Mr.
this
Chairman?
hearing.
Well, that's for the next hearing,
Oh, I'm sorry,
that's the next proceeding.
my mistake.
So if you're ready, I'll read the hearing
Please.
procedure for this one. This was a land use request which will be considered based upon the applicable criteria and standards. The staff report lists the criteria and staff that were identified by staff as applicable to the request. It was available online and from the planning department. Testimony and evidence must be directed towards the applicable criteria. We ask you specifically identify to the commission the criteria or standards you are addressing so the commission may consider your testimony in relation to those criteria and standards. If you do not identify the criteria or standards you're addressing, the commission is not obliged to guess which standards or criteria you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission and the parties an opportunity to respond to the issue precludes raising the issue to the City Council and the Oregon Land Use Board of Appeals based on that issue. The failure of the applicant to raise any constitutional or other issues relating to any proposed conditions of approval with specificity to allow the commission to respond to the issue precludes an action for damages in circuit court. The hearing process will be as follows. First, a presentation by staff, then testimony by the applicant up to 20 minutes, followed by testimony by parties in support of the application, then by testimony by parties opposed to the application, and finally testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes. Any person in attendance may cede his or her time for testimony to another person, except to the applicant, but in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood association, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Following that would be the applicant's rebuttal up to 5 minutes, and then commission deliberation, including a statement to the applicant by the commission of any proposed conditions of approval different than contained in the staff report, and the applicant's response to the commission's conditions of approval proposed following commission deliberation. The time limits do not include time spent responding to questions from the commission. Testimony by attorneys, representatives, and witnesses on behalf of which is part of the presentation by a person shall be counted within that person's time limit. It is assumed that persons are testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they are representing. As stated in the public notice, the deadline for submission of written materials was noon today. No written materials may be submitted to the commission tonight. Any person may request an opportunity to present additional evidence by requesting a continuation of the public hearing. At this point, I would ask potential conflict of interest declared on behalf of each of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known, present, or anticipated future business relationship with the project or the applicant. It is possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244-020. Now, at this point, I would ask the commission members, please declare if you've had any ex parte contacts, including a site visit, if you have any bias on the application, any financial conflicts of interest to declare, and please state your business or employment. Commissioner Berardi.
Hi, my name is Craig Berardi. Hi, my name is Craig Berardi, financial consultant with Northwest Pipe. I have not visited the site. I have no ex parte contacts, no bias, and no financial conflicts of interest.
Poinsett.
My name is Bruce Poinsett. I am a construction safety consultant with GEW LLC. Have no contacts, no financial interest, no ex parte contact, no conflicts at this time.
I'm Dwight Sangray. I'm an engineer, civil engineer.
Can you turn your microphone on?
Yeah, I am not,
There we go.
very good, thank you. I am familiar with the site. I have not been on the site, nor have I looked at the site from the standpoint of this hearing. I have no contact with either the developer or those who have commented about this. I have no bias and I have no financial interest in the outcome of this proceedings.
Good evening, my name's Jeff Shearer. I'm a retired contractor. I am very familiar with the site. A friend of mine lived in the area. I've had no ex parte contacts, no bias, and no financial conflicts of interest.
Good evening. I'm Randy Arthur. I'm a civil litigation attorney with the Portland office of the Bullivan Bailey Law Firm. I've had no ex parte contacts. I have not made a site visit. I have no financial interest in this application and have no disqualifying bias. Thank you.
Good evening, my name is Kirk Smith. I'm a real estate land use attorney with the Portland office of Buckhalter. The city provided me a list of the parties and their consultants, and I ran through my conflict system, and I have no conflict. I've not visited this site. I have no ex parte contacts, no bias, and no additional financial conflict of interest.
Good evening, my name is Mark Silent. I work for the Intuit Corporation. I've had no ex parte contacts. I've not visited the site. I have no bias and no conflict of interest and no financial conflicts.
Thank you. Is there any person who wishes to challenge the commissioner's right to consider the application? Seeing none, Associate Planner Ellen Davis with a staff report.
Good evening, Commissioners. My name is Ellen Davis. I'm an Associate Planner for the City of Lake Oswego. I'll have my PowerPoint up in a second. The site I am discussing is located at 1880 Twin Points Road. It is a flag lot located on a private portion of Twin Points Road with with no frontage on the public portion of Twin Points Road. The flag lot was created by partition LU 2038. The buildable portion of the site is located between the existing access lane portion of Twin Points Road and Oswego Lake, roughly where the number 1880 is in that area. The flag lot standards and the partition conditions of approval require a 6-foot screening fence along the side and rear property lines of a flag lot. This site is very steep. As you can see from all these 2-foot contour lines in this survey, it ranges from a 60% to a 70% slope from the access lane down to the lake. A major variance was already granted with the partition to remove the fence requirement for the portions of the side property lines above the access lane, which is a rock face, and planning staff have interpreted that the flag lot fence standards do not apply to the rear property line along Oswego Lake. So the request is for a major variance and partition modification to eliminate the requirement to construct a fence along the side property lines indicated with red dashed lines in this image. The first criterion for a major variance is that the request is necessary to prevent an unreasonable hardship. In this case, the hardship is the steep slope, which would make fence construction very difficult and expensive. The slope is an existing physical circumstance of the property, and it was not created by the applicant. The next two criteria look at potential impacts of the proposal and perceptions of the neighboring property owners. In this case, the proposal would avoid construction of fences on a steep slope, so the proposal would result in less disturbance of the hillside. No negative impacts are expected. Looking at the neighbors' perception, the two nearest neighbors at 1870 and 1890 Twin Points Road submitted letters in support of the application. One of the reasons they cited is that there are no other fences in the neighborhood or on the neighboring properties, and that privacy fences would look out of place in this area. There were no comments in opposition. The last criterion is that the request is the minimum variance necessary to alleviate the hardship. Staff finds that due to the steep slope, the minimum variance necessary would be eliminating the requirement for screening fences for this flag lot. Staff finds that the applicable criteria are met and recommend approval with the conditions listed in the staff report. Thank you.
Are there any questions for Ellen? Kurt?
So I looked at the code section on flag lots and the screening and buffering of the code that I guess we're seeking a variance from. And I guess I have two questions. One is, when I looked at screening and buffering for flag lots, just generally, almost every city code that I could find, they had, if there was a flag lot, that there would be screening and buffering. And so, but I couldn't find anything, if, you know, like basically if you're an urban planner and you're gonna have a flag lot, this is the reason that you require screening and buffering. So I mean, I presume there's a reason that not only Lake Oswego has this requirement, and almost every jurisdiction that I could find has the same requirement. So I was curious what that is. My second question is, I saw in the code that basically, the way I looked at it is if the neighbors agree to this, not having a buffering on a flag lot, then it's okay. And so my second question was, the neighbor to on the other side of the lake, not 1890 or 1870, it didn't have an address, so I couldn't tell who that is. If there was any comment from that neighbor that would, I guess, benefit from one side of the lot, that the fence, I guess, would be located.
Okay, great.
Okay,
So
thank you.
for the second question, I'll start with first. So if you'll put on your imagination cap and go back to some of those maps I was showing, the property that we have not received any comments from is actually over 100 feet away from this site. The house itself is very far down that access lane at the end and at a lower elevation. So it's not directly next to this house. We didn't hear anything back from that neighbor, It was just the two physically closest houses that wrote in support. But we didn't receive anything in opposition either from the neighbor kind of farther down, down the hillside. And regarding the screening question, kind of the purpose of the screening, so the idea behind flaglot screening is that flaglots are a form of residential infill, creating greater density within residential neighborhoods. And so there's a requirement to screen those new properties that are being kind of squeezed into existing neighborhood characters and patterns. So the idea is to screen that development. We have a lower height limit typically. We have screening requirements to decrease the impacts of that new house that's being squeezed into an existing block. In this case, though, we have a very steep topography. So these flaglot screening fences, most of the fences would actually be below the sight line of the immediate neighbors. So it wouldn't really provide that screening that you would get on if you think about a typical flat lot where all of the neighbors are on the same level and all kind of looking into each other's backyards. This is a very different site where you're not all looking into each other's backyards. So the screening fences in this case wouldn't provide the privacy that would be rendered in kind of a typical flaglot situation in a more normal neighborhood that doesn't have this steep topography.
Any other questions? Okay. The applicant, are you here? The applicant is not here.
The applicant is out of state, as I understand, and so they were hoping to Zoom in and provide their presentation.
Does he have to be here, Evan?
The applicant does not have to be here. You can consider the evidence based upon everything that you've received. Although I would suggest if we're trying to reach the applicant, let's wait a minute or two to reach the applicant. But I don't want to take it out of order because anybody in opposition would speak in relation to those comments. And then I guess while we're killing time, this is a good demonstration of why the provision that says if you want to zoom in, you accept the risk that either your system will fail or our system will fail and you're not able to be present, then you waive that right.
Okay.
So.
Hi, Kat.
So Neil, we're gonna have you talk via the phone and I'm gonna try to go through your slides. So you can just tell me next slide and I'll click through them.
Okay, sounds good. Let me know when you're ready.
The council room can hear you, Neil.
Okay, well, that's great.
We're ready.
We're ready, go.
Okay, great. Thanks for finding me time here, everybody. Sorry we're having Zoom problems. I don't know what's going on there. So this is to talk to you about a fence variance I'm requesting. On page 2 there's just a note that the city requires now Zoom is trying to tell me something. Hold on, get rid of it. The city requires a 6-foot screening fence around the left, right, and rear of a newly created flag lot. Obviously, I understand why, and I've seen it many times in flat areas. The reason I'm requesting a variance is I've got quite an interesting lot that's creating a few challenges trying to put a fence around it. So I'll go through that with you, and then we can answer any questions you may have. So, first reason to the variance request is that there are no fences at the rear of any lakefront property. If you look at my lot, we'll get to that in a second, I divided and created that flag lot from the house that was further up. And to build a fence either side, I would have to build a fence either side of my dock, probably in Lake Court property, and it would have to sit behind my dock, and it came by it from the lakeside, look and think it was kind of strange that you've got a lakefront property and you've got a big 6-foot fence running across it. Second issue, there's no fences anywhere in this area of Lake Oswego on the lake. If you flick to page 5, Kat, that'll show you the area. I tried from the lake to take a photograph that was wide, and you can see the early stages of development there on my lot in front of the dock. The house above it with the blossom tree was my old house, and we divided from there. So as you can see from the left, I have no houses next to me. To the right, the Speckler's house is more than 100 feet away from my property line. So it would be something that doesn't exist anywhere else. And in fact, if we go to page 6, it's a good way of seeing how far away my construction project is to any other house locally. So 1870, which is above me, is owned by the Andersons, and they're must be 100 and something feet above, so they can't even see my house. And then 1890 is more than 100 feet, and 1900 is more than 300 feet away. So it's not like we're trying to screen to provide privacy to the neighbors. And then one of the other challenges, which you can see better probably on page 7, is that we had to build halfway through the excavation a 125-foot retaining wall, which drops up and down in some places more than 15 feet. And on page 7, I think it is, you can see a bit of more of a close-up of the lot, and you can also see the slope there that's impacted. We've also got a PGE power pole now right on that property line, so that would create a bit of a challenge too. But you're talking about building potentially a fence down a sheer cliff, literally straight down. There's not even much of a slope there. And then next slide, to help understand the topography of this lot, many people have said I'm crazy trying to build here, but the lake elevation is at 98.6. The left corner of my lot at the road is 152, and the right corner is just over 170. And there are also a large number of trees along the right border with the house that's closest to me that makes it more difficult as well to maneuver a fence through those trees. So there's and they're large and established trees as well. And then the next problem we've got is the land itself. If you flip to page 9, you can see the type of material that we've had to excavate. On the top of that slope, there was 6 to 12 inches of, I'll call it peat, soft, years worth of trees that have dropped, pine needles, etc. So there isn't any really dirt, as you call it. And then below that peat is essentially rock. To excavate that lot has taken us more than 4 months and almost $400,000 of cost. And there's 3 examples there on that slide that show you the type of material that we're dealing with. I shopped around a little bit. It was quite hard to find a contractor that would even estimate what a fence would cost. Most of them want a rock clause, which basically says they'll do the work for time and material. We've already installed over $140,000 worth of micropiles to support the foundation straight into the rock face. So trying to dig down, the one contractor that took a stab at it said he thought that the fence would be in excess of $50,000. And that's with a rock clause that says, depending on how difficult it is to get posts in on an angle, there could be even more cost. And then I think my final point is there really is no impact to my neighbors on this request. In fact, two of them, the Andersons that are north of me and Stecklers to the right of me, I think both wrote letters of support to not have a fence, concerned about how the landscape of the area would look, the sheer ugliness of it, and it would also prevent the movement of wildlife. And then if you flick through the pictures tab and get to an aerial view before construction, I think it's like page 10, you get a good view of that retaining wall before we start the construction. And then the picture after it shows you once we were at the first floor construction level, and you can see the sheer cliffside of that retaining wall that we built to have to protect the road from seepage onto the lot. And then if you go to the very last page, and then I'll shut up, you can see literally the photograph that I took from the lake last week that shows you the progress. So we're pretty much framed, but left and right, you can see that the steepness and where we would have to start that fence is also a bit of a challenge. To the left of the building, there's half of a white van, and starting it there, then we go down a 15-foot cliff, and then 45 degrees down to the lake. So I'll take a breath and shut up and see if there's any questions.
Are there any questions for the applicant? Thank you.
Okay.
Okay. Now we move in to see for testimony. I don't have anybody registered for testimony for or against? Correct. Okay. I guess then we would move directly into Evan.
Well, of course, there would be no rebuttal then.
No.
And I assume the applicant doesn't wish to continue the public hearing to present additional evidence, nor does the applicant wish to submit any final written argument.
Applicant, are you still with us?
Oh, I'm sorry. I thought you were done with me.
No.
Do you wish to submit final written argument which would delay the commission's deliberation, or do you wish to submit based upon the evidence and argument that has been presented?
Based on what I've already presented, yes.
Proceed to deliberation, Mr. Chair.
Thank you. Does anybody have any comments?
Well, I would just say that I think the purpose of this fence screening requirement on flagged lots does not apply here on this extremely sloped lot. I know that there's apparently no opposition to the application from any source. Apparently, immediately impacted neighbors approve and support the application. It looks like there are no other fences in the adjacent area, so the fence would not match the other open landscaping sloped area. So I will be voting in support of the application.
Is that a motion?
At the invitation of the chair, I move approval of this application.
Second.
Second.
As noted under the conditions per the staff.
Yes, pursuant to the staff report with all conditions of approval and stipulations in the report.
Thank you. Kat?
Shearer?
Yes.
Arthur?
Yes.
Smith?
Yes.
Silent?
Yes.
Berardi?
Yes.
Poinsett?
Yes.
Sangre?
Yes.
7-0.
7-0 passes.
There's a tentative decision by the commission with written findings brought back to the commission on the 6th of July. That's Wednesday due to the July 4th holiday.
Okay. Thank you.
Thanks very much. Really appreciate your support.
Good night. Okay, now we're going to move on to AP 2203, designated as 499-22-000-160 tree, and AP 22-04, designation 22-000-158 tree. We're going to use it as a consolidated hearing. The two applications below are for side-by-side lots owned by the same applicant. The commission will hear testimony on both applications in one consolidated hearing. The following time limits will apply for testimony on both applications together. The applicant will have 20 minutes. The representative of a recognized neighborhood association, homeowners association, government or government agency, or incorporated public interest organization shall have 10 minutes. Individuals will have 5 minutes. The applicant will be given 5 minutes for rebuttal.
Thank you, Mr. Chair. The hearing procedure, in addition to that, is stated by the chair. This tree removal hearing is to be considered based upon the applicable criteria and standards. The staff report lists the criteria that staff identified as applicable to the request. It was available online and at the planning department. Testimony and evidence must be directed towards the applicable criteria. We ask you to specifically identify to the commission the criteria or standards you're addressing, so the commission may consider your testimony in relation to the criteria or standards that you are addressing. If you do not identify the criteria or standards, the commission is not obliged to guess which standards or criteria you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission the parties an opportunity to respond to the issue precludes appeal to the city council based on that issue. The chair has indicated the time limits. I would just add that if any person wishes to cede his or her personal individual time to another person, you may do so, but in no case shall any person's testimony be increased to greater than 10 minutes. Following the applicant's rebuttal, if any, the commission deliberation, and then a statement to the applicant by the commission of any proposed conditions of approval different than contained in the staff report, and the applicant's response to the commission's conditions of approval proposed following commission deliberation. Now, those time limits do not include time spent responding to questions from the commission. Testimony by attorneys, representatives, and witnesses on behalf of which the part of the presentation by a person shall be counted within that person's time limit. It is assumed that persons are testifying on their own behalf unless they expressly identify the recognized neighborhood association, government or government agency, or other incorporated public interest organization they are representing. As stated in the public notice, the deadline for submission of written materials was noon today. No written materials may be submitted to commission tonight. Any A potential conflict of interest declared on behalf of each of the DRC members to the extent of the business or employment, which each shall identify. Unless declared otherwise, the respective DRC member does not have any known present or anticipated future business relationship with the project or applicant. It's possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244-020. Now, I would ask the commission members to please declare if you've had any ex parte contacts, including a site visit, if you have any bias on the application, if you have any financial conflicts of interest, and please declare your business or employment. Commissioner Berardi.
Craig Berardi, financial consultant with Northwest Pipe. I've not visited the site, have no ex parte contacts, no bias, no financial conflicts of interest.
My name is Bruce Poinsett. I'm a safety consultant with GEW LLC. I have no ex parte contact. I have not visited the site. I have no conflicts whatsoever.
My name is Dwight Sangre. I'm a civil engineer. I've had no ex parte contacts relating to this. I have no bias related to this, no financial interest. I am very familiar with the site. It's located in an area where I travel every day, but I have not physically visited the site.
My name is Jeff Shearer. I'm a retired contractor. I have not visited the site. I have had no ex parte contacts. I have no bias and have no financial conflicts of interest.
I'm Randy Arthur. I'm a civil litigation attorney with the Portland office of the Hauser Bailey Law Firm. I have had no ex parte contacts. I've not made a site visit. I have no financial interest in the application, and I have no disqualifying bias.
My name is Kirk Smith. I'm a real estate land use attorney with the Portland office of Buckhalter. The city provided me with a list of the applicant and their consultants, and I ran those names through our conflict system, and there was no conflicts generated. I've not visited the site, have no ex parte contacts, no bias, and no additional financial conflicts of interest.
My name is Mark Silent. I work at the Intuit Corporation. I've had no ex parte contacts. I've not made a site visit. I have no financial conflict of interest and no bias.
Thank you. Is there any challenge to Commissioner's right to consider the application? Seeing none, and before turning it over, I just remind everybody who wishes to testify that this is a consolidated hearing, but it is regarding each specific piece of property and each tree on that property that is the subject of the tree removal. So please direct your attention, or please call out the specific tree or site that you're talking about. Try to make that clear in your testimony. With that, Associate Planner Daphne Sissel with her report.
Good evening, Commission members. My name is Daphne Sissel. I'm an associate planner here with the City of Lake Oswego. Can you hear it? That's okay. Is that better? As stated, this hearing is in regards to two separate applications for type 2 tree removals on abutting lots owned by the same property owner. The properties are at 529 8th Street and 541 8th Street. First, before I start my presentation, I would like to mention that Exhibit F005 was not listed as an exhibit in either of the staff reports dated June 10th, 2022, but it was referenced in both reports and available online. Also, for both records, I would like to introduce Exhibits F006 and F007, which are supplemental information submitted on behalf of the applicant today. And for record AP 22-03, application 499-22-000-160-3, exhibits G324 to G342 are comments received in opposition today. And for record AP 22-04, application 499-22-000-158-3, exhibits G326 to G345 are comments received in opposition today. The comments reiterated previous opposition to tree removal, with the exception of exhibit G332 for record AP 22-04, which disagrees with staff analysis regarding a tree's significance. The staff report discusses the analysis of determining the significance of a tree, and I will be addressing the type 2 removal criteria in the presentation tonight. So first I wanted to cover just a quick background of this property. It's important because the two properties used to be developed with one small single-family dwelling. As stated in the staff report, a legal lot determination was done and was requested by the property owner in 2021. And it was determined that there are two legal lots of record. So both these properties are currently under review for building permits for single-family dwellings and are requesting tree removal. The lot to the south is 529 8th Street and is requesting four type 2 tree removals. The lot to the north is 541 8th Street and they are requesting 5 type 2 tree removals. I've tried to highlight them here just with the yellow highlight. All type 2 tree removal applications must meet Lake Oswego Code requirements, criterion 1 through 3, as listed in LOC 55.02.080. Criterion 1 is the reason for removal. Trees must have a reason for removal for either development or landscape reasons. 529 8th Street lists the reason for removal as development related to construction of a new single-family dwelling. The site plan, as shown here, shows the trees requested for removal as related to a proposed dwelling. So staff finds this criterion met for this application. 541 8th Street also lists the reason for removal as development related to construction of a new single-family dwelling. Again, the site plan here shows the trees requested for removal as related to the proposed dwelling. Staff finds that this criterion is met for this application. Criterion 2 addresses tree removal impacts on erosion, surface water, and protection of adjacent trees or existing windbreaks. Regarding erosion control and flow of surface waters, city staff must review proposed measures for erosion control and stormwater management on site for new construction. For protection of adjacent trees, staff finds that the trees on both properties are not providing protection for other trees other than the trees on the abutting lot, to the north for 529 8th Street and to the south for 541 8th Street. Staff finds this sub-element can be met if a condition of approval is imposed that these permits are contingent on the approval of both permits. See Condition A. With these city requirements for approval of on-site erosion control and stormwater management and imposing the condition of approval for the permits being contingent on the approval of the other, staff finds that this criterion is met for both applications. Criterion 3 addresses tree removal impacts on the character or aesthetics of the neighborhood. The standard is met if the removal of the trees does not involve a significant tree, alterations to distinctive features or continuity of the neighborhood skyline, trees serving as a visual screen between different neighborhood zones, a street tree, or removal of 50% or more of a stand of trees. I will be focusing my presentation on the elements that are relevant to these applications, specifically significant trees, alterations to distinctive features or continuity of the neighborhood skyline, and removal of 50% or more of a stand of trees. Significance is defined as a healthy, non-invasive tree over 15 inches in diameter that is considered significant to the neighborhood due to size, species, or distinctive character, or is the only remaining tree on the property. For 529 8th Street, all 4 of the trees were listed as fair condition, which the city has used as an indication for health. All 4 of the trees exceed 15 inches in diameter, and all of them are Douglas fir trees, which are non-invasive native species. Since all 4 trees meet the first 3 elements, they will be looked at individually for significance due to size, species, or distinctive characteristics. Looking at size, tree 10310 is the only individual tree that appears to be substantially bigger or taller than the other trees. For species, Douglas firs are not unusual in this neighborhood. And distinctive character, no individual tree provide distinctive characteristics to the neighborhood. Therefore, tree 10310 is found to be significant to the neighborhood due to size. These trees are also not the only remaining trees on the property, as there is one other tree on the property that will be retained. Even if individually trees are not considered significant due to size, species, or distinctive character, the applicant must show that their removal will not have a significant negative impact to the distinctive features or continuity of the skyline, and address if the proposed removal is greater than 50% or more of a stand of trees. The applicant stated in the application that the removal of the 4 trees at 529 8th Street would create a significant change in the treed skyline. This photo on this slide shows a view of the trees. I've tried to circle the ones that are on 529 8th Street. And just looking at the photo, staff agrees that the proposed removal will have a significant negative impact on the character or aesthetics of the neighborhood due to the loss of continuity of the neighborhood skyline. The sub-criterion is not met. For looking at removal of 50% or more of a stand of trees, the applicant stated in the application that the trees are individuals and do not have a contiguous crown. But just looking at aerial photos and taking a quick measurement in a mapping system, Staff finds that the trees are located within a group of other trees or as part of a stand of contiguous canopy that is at least 15 feet high and 120 feet wide. More than 50% of the stand for 529 8th Street is proposed for removal. This sub-criterion is not met. Because the tree removals will have a significant negative impact on the character or aesthetics of the neighborhood due to the loss of continuity of the neighborhood skyline, and the proposed tree removal is greater than 50% of a stand, reasonable alternatives to tree removal must be considered. This slide shows the current footprint that is under review for the building, for the new single-family dwelling. The brown, orange color is the building footprint. The greenish color is the building envelope that's available that is not already covered by the building footprint. As you can see, I've highlighted the trees again. It might be a little hard to see, but 3 of them are either within the footprint or very close in proximity to the footprint of the dwelling. And the only way, let's see if I can highlight it here. The dwelling is already sitting on the back, on the rear setback here, and then along the sides on the north and south, it is almost set at the side yard setbacks. It has an inch or 2 of movement, and that's it. So the only movement this building footprint has is to move west, where it would not provide adequate protection for the 45-inch Doug fir that they're trying to retain up here. This was an alternative footprint that they looked at for trying to retain additional trees. It's a footprint that has been flipped, so the patio is on the north side instead of the south side. As you can see, 3 of the trees are still within the footprint. The building permit that is under review, this one that I was showing earlier, has been reviewed by planning staff to verify that it meets all applicable zone standards. Staff notes that the setbacks and lot coverage for the proposed dwelling comply with the requirements of the R6 zone regulations. And this alternative site plan was the same. It meets all the zoning requirements, but it doesn't retain any of the trees, or it doesn't provide adequate protection for any more of the trees. The tree that's in the back, let me see if I can highlight here. It's back near the alley. The reason that one is not a good candidate for retention is there are 2 additional invasive trees. There was one here and one down here. They're a little bit hard to see, but they were already removed, and this puts this tree at risk for wind throw. So we are saying that the utilities are coming through right underneath there, and the driveway will impact the roots on that tree. So even if the utilities are moved and the driveway is rearranged or redesigned, the risk of wind throw makes that tree not a reasonable retention. Okay. So looking at 541 8th Street, looking at significance again, as a healthy, non-invasive tree over 15 inches in diameter that is considered significant to the neighborhood based on size, species, or distinctive character. 4 of these trees are listed as poor condition, and only 1 of them is listed as fair condition. All 5 of the trees exceed 15 inches in diameter, and 4 of them are Douglas fir trees, and 1 is a big leaf maple, which are all non-invasive native species. Since only tree 10323, highlighted here, meet the first 3 elements for significance, it will be looked at individually for significance due to size, species, or distinct characteristics. This photo here, you can see that tree 10323 does not appear to be substantially taller or bigger than other trees. It's a Doug fir, which is not unusual or rare in this neighborhood. And it does not provide distinctive characteristic to the neighborhood. Tree 10323 is found to not be significant to the neighborhood due to size, species, or distinctive character. Tree 10323 is also not the only remaining tree on the property, as there are 2 other trees on the property that will be retained. So again, even if individually trees are not considered significant due to size, species, or distinctive character, the applicant must show that their removal will not have a significant negative impact to the distinctive features or continuity of the skyline, and address if the removal is greater than 50% or more of a stand of trees. I'm using the same photo I used before and just circling the trees on 541 8th Street. And this is a view from 7th Street, so a block away. The applicant stated in the application that the removal of the 5 trees at 541 8th Street would create a significant change in the treed skyline. Staff finds that the proposed removal would have a significant negative impact on the character or aesthetics of the neighborhood due to the loss of continuity of the neighborhood skyline, just looking at this one view from the street. The sub-criterion is not met. The applicant stated in the application that the trees are individuals and not part of a stand with a contiguous crown. Again, looking at an aerial photo and just taking a quick measurement in a mapping system, staff finds that the trees are located within a group of other trees or as part of a stand of contiguous canopy that is at least 15 feet high and 120 feet wide. More than 50% of the stand for this property is proposed for removal. The sub-criterion is not met. Again, because the tree removals will have a significant negative impact on the character or aesthetics of the neighborhood due to the loss of continuity of the neighborhood skyline, and tree removal is greater than 50% of a stand, reasonable alternatives to tree removal must be considered. This again is the current building plan proposed, or the building footprint proposed. As you can see, 3 of the trees are within the footprint of the proposed building. The green again is the building envelope that's available. So the only movement again, this is, there we go. Again, we're at the back setback, rear setback line here, and right at the side yard setbacks with just an inch or 2 of movement, either north or south. So the only movement for this building footprint would be to the west, which does not allow for adequate retention of the 2 maples that are in the front to be retained, which are here and here. The building permit for this proposed dwelling has been reviewed by planning staff to verify it meets all applicable zone standards. Staff notes that the setbacks and lot coverage for the proposed dwelling comply with the requirements of the R6 zone regulations. This again is an alternative plan that was submitted that shows an alternate proposed building footprint with the patio on the south side of the building. 2 of the trees are still within the footprint of the proposed dwelling, and the proposed footprint is as far east as it can go at the rear setback line, and the footprint sits almost on the side yard setbacks. So the only available movement with this footprint is again to move the footprint to the west, which does not allow for adequate retention of the 2 maples in the front that are to be retained. The other 3 trees in this alternative plan, this one here, and this one here, are all outside of the building construction, but are in poor condition and are not suitable for retention due to construction impacts on their roots and potential risk of wind throw due to adjacent removals. The staff recommendations for 529 8th Street are: staff finds that the approved criteria for LOC 55.02.080 have been met, specifically the exception to Criterion 3, because there are no reasonable alternatives. Staff recommends approval with the following conditions of approval. Approval is contingent on the approval of tree removal application 499-22-000158-tree for 5 trees at 541 8th Street in order to comply with the LOC 55.02.080 Section 2, protection of adjacent trees. Prior to issuance of the building permits, submit a mitigation plan showing the location, size, and species of 5 mitigation trees that must be native species, If there's insufficient space to plant all 5 trees, payment into the tree fund in lieu of planting a portion of the mitigation trees may be allowed. And prior to the final inspection for the dwelling, plant the required mitigation trees per condition B above and request an inspection by staff. The staff recommendation for 541 8th Street is basically the same. Staff finds that the approval criteria of LOC 55.02.080 have been met, specifically the exception to Criterion 3 because there are no reasonable alternatives. Staff recommends approval with the following conditions of approval. This approval is contingent on the approval of tree removal application 499-22-000-160-tree for 4 trees at 529 8th Street in order to comply with LOC 55.02.080 Section 2 protection of adjacent trees. Prior to issuance of building permit, submit a mitigation plan showing the location, size, and species of 5 native mitigation trees. If there's insufficient space to plant all 5 trees, payment into the tree fund in lieu of planting a portion of the mitigation trees may be allowed. And prior to the final inspection for the dwelling, plant the required mitigation trees per condition B above and request an inspection by staff. I have this site map that I can leave up when public comments start so people can either refer to the trees or refer to properties, and you guys will have some reference of hopefully where their comments are related to. But that's the end of my presentation, and I'm happy to answer any questions you have.
Thank you, Daphne. Are there any questions? Mark? Kirk?
I was curious about tree 10-283, the one that's near the alley. And I think I heard you say that because there was 2 trees already cut down, that now this tree's exposed to wind throw?
It has a risk of wind throw, yes.
So I'm curious, when did those 2 other trees, when were they cut down? So now this tree is exposed to wind throw?
So those 2 trees, one on the north lot and one on the same lot, are both invasive species, and that permit was already issued. They are an over-the-counter permit, and they don't take a review from us. We just have to verify the species, and then we issue the permit.
Okay, so as I understand it, because invasive trees were cut down, now this tree is exposed to wind throw. Is that a fair characterization?
That is my understanding from their arborist and our contract arborist, yes.
Okay, thank you.
Facilities as well?
Ready?
And, yeah.
Daphne,
Facilities.
have
I
they
did mention that,
already
they didn't ask
been
about that.
cut down, those 2 trees?
I'm sorry?
Have those 2 invasive trees already been cut down?
My understanding is that they have removed the invasive trees from both sites, but I have not been there to confirm that.
Recently?
Yes.
Thank you.
Wait, if I could ask, when was the permit issued?
Excuse me, we'll get to the applicant in a minute. Thank you, though. Randy, you have questions?
I did have a question. I noted in the materials, and I'm not sure what the exhibit number is. I printed it off, but it doesn't have an exhibit number on my printout. There was an email from a Mr. David Rudowitz. This is the February 12th, 2022, 11:07 a.m. email, where he posits on page 1 what he considers some reasonable alternatives that should be considered in the application. And I didn't note that these specifically were addressed in the staff report, but I may have overlooked it. One of them was reconfiguring the basement to protect tree roots. Another was relocation of the stormwater handling cisterns. Has staff addressed these so-called reasonable alternatives in the staff report, or is there any response to that?
I can answer just about the stormwater. The stormwater in one of the back, I'll go back to this one. It used to be designed as a stormwater chamber. They decided to redesign it as, I don't know what they call these, a dry well system instead. It is a different design. As far as the basement alternatives. I mean, we've asked them just to show why the trees can't be retained. Basements are allowed in the zone, so we've asked them to just show us why the trees cannot be retained, even though there is a basement going in. The red lines on this plan show the excavation and the grading needed, so that was their evidence. And they did some air spading and excavation, which I did talk about in the staff reports, that showed that the tree roots would be impacted from the basement excavation for specifically one of the trees that shows that it's outside the footprint.
I see. So the basement is a use permitted in the zone, and it's staff's opinion that no reasonable redesign of the basement area would protect any additional trees.
So do you want to receive additional testimony from the applicant, others, and then opine on it?
Yeah, I think the applicant should address this. I mean, they could put a full basement underneath the entire footprint. That is allowed per the zone. You know, we do often get comments that say, well, they shouldn't do a basement, or they should do a smaller house, or they should only build one house. It is not staff to determine what the applicant should build. That is what is allowed by the zone. And the code allows them to, we are required to look at alternatives that would lessen the impacts on trees, but still allow development as permitted by the zone. But the applicant can perhaps address further alternatives that they may have considered for the basement.
Thank you for that discussion.
Any other questions for staff? Okay. The applicant now has 20 minutes. Excuse me. The applicant now has, 20 minutes.
Good evening. For the record, Jamie Housley, attorney for Renaissance, the applicant here, 2 Center Point, 6th floor, 97035. First, Mr. Schroep from Renaissance is going to testify. Then Mr. Sebastian with Renaissance is going to testify. Then Ms. Gersh, our arborist, will testify. And then I will come back to talk about a letter that you should have received from me regarding some legal criteria under Oregon's needed housing statute. So, Mr. Schroep.
Hello. Good evening, Commissioners. My name is Jeff Schroep. I'm the Chief Operating Officer at Renaissance Homes. I'm here to give a timeline and history of working with staff to reach a tentative staff approval. On February 11th of this year, Renaissance Homes applied for a building permit and 10 trees to be removed on 2 legal lots. Once the public comment period ended, there was an excessive amount of comments and attention to this case, and the city reached out to us and requested more information. At that time, we took that information from all the comments, looked at it, talked to the staff, and started to formulate our strategy to respond to all of the comments. First, what we did was we re-engaged our certified tract arborist, Mary Gersh, who will be speaking later on tonight. We also looked at our site plan and updated the site plan to clearly show the excavation of our foundations and shoring methods required to build a compliant new home in Lake Oswego. In addition, we looked at our stormwater requirements on our lots that are required at every new home build in Lake Oswego, and we're able to move from the more larger sizes of storm tech chambers to dry wells, which those all help to reduce some of the trees that we needed to be removed in order to build new homes here. On March 24th, the city responded to our new evidence and requested us to look at 3 additional trees that we were asking to be removed. At that point, we made an attempt using hydro excavation to further explore excavation in those larger trees and discovered the roots extending further into the root zones, making it more difficult or figuring out that these trees' roots are larger than what we initially thought. At this point, Renaissance submitted more alternative site plans to show that both sites cannot be developed without the removal of the 9 proposed trees. We increased the front setbacks of both homes on the property to retain 2 additional trees along 8th Street, one a type 1 tree and one a type 2. We also provided the city with additional information from our arborist to specify each tree to justify the removal in relations to both projects. There is that one tree that you were talking about in the back. I think it was 10283. That was actually, I believe, the city arborist required or recommended us to save that tree. And then obviously talking to our arborist, they came to that agreement to save that tree. It was because of wind throw, like the staff said. After long discussions with the city on having a fully completed application, we were able to submit our final round of evidence supporting materials on April 15th, which initiated the new comment period. It's been a long 3 months of working with the staff, and we agree with the staff findings, and that's kind of where we are today. Currently, we have 2 homes that are in the building department that have been fully approved by planning and zoning and awaiting this decision for the trees to be removed. We've been working closely with the city on this case to ensure we follow the proper procedures in our application and have provided a clear evidence that in certain and above standards of what would be expected from a typical homeowner. We believe we have completely justified the removal of all trees being applied for, and I encourage you to deny the appeal and allow the project to move forward. Thank you for your time.
Randy, before you testify, could I just ask for a clarification? You noted tree 10283 to save it. Is that what you meant to say?
Correct. When we were initially working with the staff, we came back and it was my understanding that we said we probably could save that tree. However, the staff arborist came back and said wind throw would be a problem and that the city's arborist recommended to be removed.
I think you said to be saved. So
okay,
I'm sorry.
Apologize. Thank you.
Go ahead, Randy. I'm sorry.
Oh, hello. Design Review Board. Randy Sebastian, Renaissance Homes, President, 16771 Boones Ferry Road, Lake Oswego. I've been doing this 38 years. Seen it all, heard it all. You guys probably have too. It's fashionable right now to stop housing, as you can see with the crowd tonight. The woman across the street was so mean and threatening to my employees, we had to call the Lake Oswego City Police, and she was given a warning. As in most of these, it's not about the trees. It's not. The main reason is stop traffic, more cars on the road. This lot is being used for parking for the school across the street, and a lot of people park there on that they won't be able to park there when we build. As we all know, Senate Bill 100 in 1973 established the urban growth boundary. A lot of people don't know this, but only 2% of Oregon's landmass is available for residential housing. The rest is forest, farm, county, state, federal lands, industrial. Again, only 2% of Oregon's landmass is available for residential housing. I get it all the time. You guys probably do too. People move here from out of state. And for trees, they'll say these are old growth trees. Well, they're not. They have never seen an old growth tree. They're not around. This place was clear cut in the 30s. I know that because my grandparents owned a large part of First Edition. My grandmother grew up there. She went to Westland High School before there was a Lake Oswego High School. My dad grew up there, and around my family they called it Oswego. It was never Lake Oswego, it was Oswego. So these are not old growth trees. And people will also use the term mother tree. Well, that's just a term. And to me, people lose credibility when they talk about old growth and they're not, or mother trees, which that's not even a term. We meet the code. Lake Oswego has a very, very strict code. We all know that, and it's a great code. We support it, and we support the staff supporting us, and we do everything right. We work really hard to provide quality homes in Lake Oswego. In fact, sadly, most of my builder peers have left. They've left the state, they've left the city, they're not building anymore. There's very few people building homes in Lake Oswego anymore. You know, it's a big thing where not in my backyard. Nobody wants change. Nobody wants trees cut. Nobody wants more traffic on the road. And it's, again, it's fashionable to stop housing. And, you know, I've had people go, well, I go, don't you think there's trees cut when your house was? It's like, oh no, my home was built in the 80s. People didn't care about it then. They care about it now. Well, people care about trees and they care about the environment all the time. And, you know, it's just funny. And I don't know, again, I'm rambling a little bit just because I deal with this all the time. But where are people gonna live? You know, there's not enough housing. We have a housing shortage, and our attorney will speak to that more. But as a society, we need to provide housing. There's not enough of it, and there's a lot of people trying to stop it. So thank you very much.
Good evening. This is on. My name is Mary Gersh. I'm a International Society of Arboriculture certified arborist. I'm also a tree risk assessment qualified arborist and a member of the American Society of Consulting Arborists. I examined the trees carefully on these sites and was there when they hand dug exploratory trenches and hydro evacuated exploratory trenches to determine where the location, the number, and the size, and the condition of the tree roots to determine what the impacts would be to the trees. Renaissance changed their preferred house design by moving it back to preserve that Douglas fir in the front. The invasive species of trees are being removed. The trees within the building footprints or close to the excavation areas of the foundation cannot be preserved because of the root disturbances would be too much. It would exceed what the tree could withstand. I agree with the staff decision that the project satisfies the tree code. My report of April 12th, 2022 is in the record, and I'd be happy to answer questions, but I'd start with that tree in the back. I think it's 10283. When we were talking about wind throw there, of course it's impacted by those two invasive species being removed, but the vulnerability to wind throw was a combination of the 6 larger Douglas firs further in the lot, that it would be more vulnerable to wind throw for the removal of those 6 trees for this tree alone. Obviously, also, the invasive species have an impact. And you look at that in combination of it's going to be exposed to much more wind, plus it is also going to have root impacts because of the construction. So I wanted a little clarification there to help with that. So if anyone has questions, I'd be happy to try to answer them.
We'll get to questions after, I think your attorney wants to say something?
Yes, I do. Thank you, members of the DRC. I submitted a letter last week discussing this appeal, and specifically I wanted to touch on some of the highlights to that letter. Again, first of all, we agree with the staff and their very thorough analysis that we meet the criteria here, and we are accepting of the conditions of approval suggested there. But secondly, we do believe that the City of Lake Oswego ordinances that were raised by the appellant violate ORS 197-307-4, which is Oregon's needed housing statute, that specifically require criteria only be applied that are clear and objective. So the way Oregon's needed housing statute works is it applies to all housing in the state of Oregon. Specifically, this property is in first edition. It's within the UGB here. The properties are zoned for R6 residential use. And Table 19 of the city's housing needs analysis identifies detached single-family housing on lots larger than 5,000. Therefore, it meets ORS 197-303-1 under the definition of needed housing. Again, specifically, ORS 197.307 mandates that only clear and objective standards may be applied to the development of housing, which this is. Tree standards that are not clear and objective simply cannot be applied to this application and therefore provide no basis for the denial of this application, nor may further conditions of approval for mitigation be applied to them. Specifically, LO 5502-0802, in the appeal, it alleges that the application fails to comply with the tree removal criteria, and specifically that code specifies removal of trees considering proposed mitigation measures will not have a significant and negative impact on erosion, soil stability, flow of surface waters, protection of adjacent trees, or existing windbreaks. Again, the staff report concludes that the erosion control is managed as part of the construction of the proposed houses, but this ordinance violates ORS 197.307.4 for failure to be clear and objective. And this is under the Group B LLC v. City of Corvallis case, where it talks about when you have a list of enumerated numerous factors for measuring compatibility with surrounding development, they're not clear. So again, you have essentially 5 standards being looked at within that one criterion. And therefore, that fails under the Group B LLC case for numerous factors under ORS 197.307. Turning to LO 5502-0803, the appeal alleges that the application fails to comply with that. And that provision talks about trees having a significant negative aesthetic on the character or aesthetics of a neighborhood. Again, that criterion is not clear or objective, and there's numerous cases on this direct point. One of the ones that would be specific to this would be the Legacy Development v. City of the Dalles. That's a brand new case from 2020. It's cited in our material here. Specifically, the staff report talks about an interpretation for significant to the neighborhood. And it goes on to define that, and again, that's cited in our letter. LUBA has held where a criterion that requires a definition is not clear and objective, again, under the Group B LLC case. We've provided some additional analysis and citation to the law on these matters, but again, the thread is that the City of Lake Oswego's tree ordinances do not meet that clear and objective test required by ORS 197.307.4. We believe that some of the testimony you'll hear tonight will also ask for additional mitigation requirement, and they'll try to cite to additional citations in the code, such as 5502.084 and 5502.094. Again, those specific sections require subjective and value-laden judgment. Again, they would not meet the needed housing statute under ORS 197.307.4. Specifically, subjective latent criteria that are intended to mitigate tree removal that are not clear and objective, that would address sort of a potential negative impact that require a subjective analysis would fail under the Legacy Development v. City of Dalles case, again, cited in our letter. So I know we have a bit of time here, but I'll try to wrap up because I know this will be a long hearing. The staff decision and staff report detailing the appellant's comments are exceptionally thorough. They carefully document the applicant's expert evidence and explain why the tree removal satisfies the local code. And the appellant's contrary assertions that it fails to demonstrate that the staff decision is erroneous in any manner. And thus, we ask that the DRC deny the appeal and allow the housing to be built. Again, in the alternative, The proposed housing is protected by ORS 197.307.4 state law, which prohibits the application of subjective and value-laden code to deny proposed development or impose additional conditions. There's a recent case just this April, Hendrickson v. Lane County, again, where LUBA confirmed that a local code that is more restrictive than allowed by state statute is not within the range allowed for the discretion of local government. The cautionary tale here is that a jurisdiction that inappropriately denies a needed housing also exposes themselves to attorney fees. And having successfully won one of those cases in the city of Dalles, LUBA does award them. So with that, we urge you to deny the appeal and allow this housing project to proceed without further delay. And with that, I'll rest my testimony. Thank you.
Thank you. Are there questions of the applicant? Craig? Mark? Right. I mean, Kirk.
I guess I have two questions. On the wind throw with respect to 10-283, so is the theory that when you take down other trees, then there's a possibility that there's going to be damage to the remaining tree? Is that the theory?
The theory is that all the trees fight the wind together and their root systems are developed to withstand wind based on its surroundings. And when you significantly alter its surroundings, if you say the wind is coming from the west there, 6 large trees are going to be removed. So that tree, the 10283, only has a root system to tolerate and withstand the amount of wind it traditionally or normally got in its 50 years or 70 years being there. When you remove those other trees, all of a sudden it's going to be subjected to the increased wind that it never really had to fight before all by itself. So it doesn't have the root system to withstand that. And also when you're talking about, it's going to have some root loss based on construction impacts. So that is the double-edged sword kind of there. It's more vulnerable because the other trees are removed, and it will be more vulnerable because it will suffer some level of root loss.
So how far out do you look to see whether or not there might be trees in the, area that you may take down a few trees next to it, but there's other trees outside of that area that would protect it from wind throw?
I'm not aware of a specific standard of so many feet or so many trees. It's more looking at, if you had one tree there that was being removed and one tree that was going to be remaining, you can kind of see that there's not so much impact. But when you see 6 large trees, and most of those trees, I think the 10310 is 47 or 52 inches, and the 10293 is in that 47, 50 inch. A lot of the trees in the middle there are even larger than this tree. So that's also a factor, because the largest trees are also withstanding the most wind, where the smaller trees are protected by the larger trees as well.
Okay, thank you. And then, Mr. Housley?
Yes.
Is it your argument based on your letter that basically, that the Lake Oswego tree code is not enforceable under LUBA?
Yes, it would be my proposition of that. And I can give you 2 examples of that. Washington County recently had their SNRO challenged at LUBA that was thrown out, and LCDC had issued a warning to all municipalities that have these types of ordinances in the state. I believe it was in August of 2020, that jurisdictions that have subjective and non-clear and objective criteria need to update their codes to comply with ORS 197.307.4. More specifically, just 2 weeks ago in the city of Portland, I was before a hearings examiner in that jurisdiction where an appellant raised very similar arguments trying to protect trees, and that hearings examiner concluded that the city of Portland's tree protection ordinance failed to meet the needed housing statute under 197.307 for failure to have clear and objective criteria.
So I guess I don't know if this is proper procedure, but has the city attorney kind of analyzed their arguments? Because I mean, I'm surprised that the argument that basically they're saying that the LO tree code is not enforceable. That's surprising to me, so.
I would say that the applicant did not raise this in their application, and therefore this matter has come up late in the process. We have not reviewed the arguments and the cases, and it takes obviously extensive time to do so. We would recommend the commission go ahead and review the case based upon the criteria that's in the code. If the commission finds that any trees are not to be removed, then we would need to then address the applicability of the argument. If the commission finds that all trees are to be removed, I think kind of from the applicant's point of view, then it's they've gotten the removal they requested, and we would not address that issue in the findings then. Point.
So you're, not to interrupt you, you're suggesting that we can make a ruling saying the tree ordinance is not enforceable?
Well, I'm saying that the issue, I would defer that issue and just decide the issues initially based upon the code criteria that you're used to dealing with. If the commission concludes that a tree is not not to be removed, is to be retained, then I would recommend we continue the proceeding, and then the city attorney's office will respond on the applicability of enforceability.
Now I got you. Okay. Kirk, sorry for interrupting. Go ahead.
Thank you, sir. I appreciate it.
Randy.
Just to follow up, Attorney Housley, it's my understanding the tree code in Lake Oswego is a standalone code that's not part of, generally speaking, not part of the development code. If it were part of the development code, technically, would that make a difference in your analysis?
That's not what Oregon's needed housing statute requires. Anytime an ordinance is directed at housing, the requirement is for it to be clear and objective.
Okay. I did have a question just to follow up on the letter I had noted earlier from David Rudowitz. I may be mispronouncing his name, taking the position that the initial application did not sufficiently address reasonable alternatives relating to reconfiguring the basement to protect tree roots. Is there any further light you can shed on that point?
Mr. Sebastian can answer that.
Yeah, I'll get on that question real quick. I'd like to just start with real quick, we don't want to lose the forest for the trees or whatever the term is, but these are legal lots. All the requirements have been met for the permit code. It's a legal lot. All the requirements have been met for the permit code. Yes, trees were lost. We've kept as many as we could. We've adjusted the footprint to accommodate the 2 trees in the front. The trees are literally in the middle of the home site and can't be saved. Tree codes may not be as enforceable under LUBA, as we all know. Tree codes should not stand in the way to stop development. We have a needed housing statute. As far as the basement goes, yeah, we obviously these are small lots, and the basement is completely allowed. We could do entire full basements here, and we're not. So, yeah, I think, obviously these are we are a home building business based in Lake Oswego. These are very, very expensive home sites. It's very, very expensive to get these through. You've seen all the different ramifications that we've dealt with and the versions of plans that we've done. And we need to build the home that we are allowed to under code. So obviously everybody say, well, why don't you only build one home? That you'll hear that tonight. Well, why don't you build a half a home? Why don't you not build a home at all? And why do you even want a basement? Well, there are a lot of basements, and there are a lot of people that want basements. So, yeah, we want to build our basements. So we haven't considered not, just like we haven't considered not building on the home, which I think a lot of people in this room would like to see these homes not built.
Are there any alternatives to the present proposed design of the basement that could be used that would protect tree roots or the trees?
Not really. If you're building a basement, you're having to excavate, and you're having to go down in the ground, and there are roots around that would be hurt. So, yeah, there's not.
It seems like the only tree that potentially would benefit from no theoretical basement would be that 10302, but that is a 30-inch tree, and the two trees next to it are the 47 and the 52. So then you're going to have the same wind throw problem of two much larger trees being taken out and one smaller tree left there, which is still going to have root loss, even if you didn't have the basement there at all. If you don't mind me.
No, thank you, Mary. Yeah, she's the tree pro. I just use lumber. That's all I do.
One of the other points made in Mr. Rudewitz's February 12, 2022 email was positing that there should be some type of relocation of the stormwater handling cisterns that would assist in protecting tree roots and trees. Do you have any response to that or any consideration to that?
We've actually made it less, as everybody, most people know, the stormwater chambers or wells are to keep water from leaving our site into the city stormwater. So it's extremely, there's a lot of engineering that goes into those to maintain our own water, and it's good. Obviously, it saves salmon, and you know, we don't have the muddy streets that we used to have in the 80s before we started doing this. I've been doing it that long. So we do what we can to minimize the impact, but we still have to contain our water. So obviously there's a lot of Monday morning quarterbacks. Well, why do you do the chamber here or over there? We do it where we best can place it.
And the stormwater chambers aren't the reason why those two trees in the front are being removed. Both of those trees are in poor condition. One of them is a Douglas fir, and if you even look at the pictures, you can see it's got a very thin canopy, and it does not look well. And the big leaf maple that's there has a large cavity throughout its trunk. So neither one of those are good candidates for retention, irregardless of, irregardless isn't a word. It's a habit. Regardless of whether or not the storm chamber was there or not. It's not impactful of that.
Thank you for your comments. I appreciate it.
Any other questions? Mary, I have just one short one. You mentioned in your comments that in moving the floor plan, you saved a tree, but you didn't identify what tree that was.
That's the big tree in the front. Initially, it was, I don't know if it was 5 feet closer or 10 feet closer, and we were looking at different options. What I get is an existing conditions site map that shows the conditions prior to any development, and then they provide a tentative footprint for where they're thinking of building, and then looking at that and looking at the condition of the trees and what's invasive and what's not, and what the potential impacts would be. You know, I felt that the building was too close to that front tree, and I said, I think you can preserve it if you move it back. And we even talked about flipping the houses and different things. So I can't tell them which trees to save. I'm like, you have to save this tree. But we work very closely together to determine which trees can safely be retained. And oftentimes, if it's close, I'll say, can you bridge over the roots? Can you do different things? And they're always very willing to consider those options, you know, so that they can preserve trees and still build a house they can sell. So I think that answers your question. It was that front Douglas fir tree. The
Great.
footprint of the house was moved to the east.
Great,
All right.
thank you.
Sure.
Okay, thank you very much for your testimony.
Thank you, everyone. Thank you.
Do we have? Okay, okay. So we don't have any parties in favor, so we will go to parties in opposition. First person is Jill Shin. And you are representing a neighborhood.
I am.
Okay.
And I'll be speaking as an individual later as well. For the record, my name is Jill Shin. I live at 949 Cumberland Road. And first of all, I wanted to thank everyone here for their time tonight, to the DRC members for their
Could
consideration.
you identify the neighborhood association you're speaking for now?
Yep, I will, in that, in my comments, it's First Edition Neighbors in Forest Hills neighborhood. And thank you all for considering upholding the tree code and preserving our important community assets. For this testimony, I'm representing the First Edition Neighbors in Forest Hills Neighborhood Association. In a unanimous vote, we decided to request a hearing on these applications. It is our responsibility to represent all neighbors in our community's best interests. We each chose to live here in our tree city because we love living amidst these large trees and all that comes with them. It is our responsibility to be stewards of the land around us. Will we enjoy and benefit from it and preserve it for future generations? When we saw this application to take down 9 type 2 trees, we knew we had to take action. We certainly understand that there will be development on this lot, but every effort must be taken to preserve as many trees as possible. It is clear this is not happening, and the applicant did not bear the burden of exploring all alternatives. I'll jump right into walking through our reasons this permit must be denied. Regarding reason for removal, 5502080, both 1 and 3, I want to remind everyone that fair means one or more problems. This could mean a broken branch or dead twig, and after enduring a record-breaking heat wave and an epic ice storm in 1 year, any tree is bound to have a broken branch or dead twig. The city also states in the report that healthy is met by good or fair. 5 of the 9 trees are deemed healthy by staff, also all meet the first 3 elements of significant. 4 of these are on lot 529. As you can see from this picture, significant trees are becoming fewer and fewer as you move numerically by street up the neighborhood. This whole neighborhood used to look like 9th and 10th, you can see on the left there. What is also significant about these trees is that they are a stand. There are no other stands of trees, especially trees this size. 5 blocks to the east, 5+ blocks northeast, 5 blocks to the north, and 2 blocks to the south. Certainly we can all agree this makes them significant. When does it end? Do we only save the last of the largest trees? The cumulative effect of continuing to cut down clearly significant trees is already visible in our neighborhood and will be catastrophic if this is allowed to continue. These trees are also certainly significant to the people who live near them. This will drastically change their property and environmental effects, aesthetics, and property value, many of whom have submitted comments or are speaking here tonight. They are experts in surface water, neighborhood aesthetics, and subsequent effects on their property. I urge you to pay special attention to what they have to say. One can simply look up at the property and also see that these trees look healthy. The people who live on this property to the left had an assessment done by Northwest Tree Specialists in October of 2021, where he stated that these trees along their property were all in fair to good condition. We had another arborist, Arbor Pro tree experts, look at the property last week, and without being able to go on the property, he classified 3 trees as in good condition, 5 in fair, and 1 poor. The applicant's report was also done well before spring growth. I think that's important to note. Given that the city at least finds tree 10310 significant, alternatives must be explored to preserve this tree. Plans should also be explored to save more or all of the healthy and clearly significant trees. In regard to erosion, surface water, windbreak impacts, 5502080, the applicant noted that both lots were flat. As you can clearly see from this picture, they are not. Oh, it looks like the video didn't show up. Well, I can play it for you later on my computer if you'd like. There's a video that's clearly showing rain rushing down the street from C down to B. From this video, you could have seen that clearly during rainstorms, water rushes down the slope. By leaving more of these trees, this water and any erosion effects on this property and on downslope neighbors would be easily controlled. Since they are taking so many trees, they have to now put in stormwater mitigation, causing them to have to take out more trees. This cannot be the only solution. To further prove the slope of the lot, we gathered information from city topographic maps and surrounding neighbors' surveys and made the following diagram. As you can clearly see, there is a 10-foot change in elevation from one side of the double lot diagonally to the other. As you can see from this picture, taking out 9 trees will leave a neighbor's redwood standing alone. Now the applicant is leaving 1 Doug fir. That tree will also be left alone at the opposite corner of the lot. These trees will endure a drastic increase in wind throw, something we've heard a lot about tonight, greatly impacting their long-term health. This applicant states that no wind throw effects, while also stating that 1 tree will need to be removed because of wind throw from removing other trees. Clearly, there will be wind throw effects. And that tree that will be removed is near the redwood, which will obviously endure increased wind throw and now root damage from removing a neighboring tree. The damage will be significant because redwoods have a very shallow root system, which can go out 50 feet or more for a tree that size. There will also be a major change in impermeable surface from 1 small cottage to 2 large homes with basements and driveways. This will certainly have an impact on surface water and erosion. You can see the approximate difference here. Regarding neighborhood character and aesthetics, 55020803. As you can see, these trees can be seen from 300 feet and much farther than that in many directions. The applicant states it will not create a gap in the skyline because they're taking all the trees down and there are no other significant trees in that area besides the redwood. This is absolutely appalling and actually affirms the point that these trees are in fact significant since no other significant trees apparently exist in the area. It also affirms that the redwood will be left standing alone and during wind throw. As you can further see from these pictures, it will create a major gap in the skyline for all neighbors in the surrounding area. It will change their views out of their windows and yards drastically. It will result in a notable increase in sunlight in their yards, affecting shade plants, changing solar impact, and cooling costs. They're also taking 15 trees total off the property, including type 1s or invasives, and leaving 3. This is a massive change in aesthetics and character. It is going from a forested lot with a small cottage to mostly clear-cut with 2 large homes. The applicant also asserted that these trees were individuals, not a stand. As we can all agree from the city's aerial view here, this is clearly a stand with no ground visible. You can also see from the diagrams that Renaissance provided to help them show that they needed to take down trees because it was affecting root systems, that this is also a stand. Seemed to work in their favor there. And if you simply look at the property, you can see it as a stand. Trees of this side, especially in a stand, are vital habitat for a multitude of species and create their own ecosystem. Taking more than 50% of the stand would massively affect the skyline and decimate this habitat. The applicant must bear the burden of proving they've explored all options to preserve more than 50% of the stand. They absolutely have not. The applicant simply states that there are no alternatives. There's no description of what they explored, if anything. Those things that were shown tonight were not part of the original application. Tonight was the first time we had seen them. Their only alternative is to save 1 extra tree. They did not change the design plans when asked to be renoticed by the city. They insist on reasonable development, which we certainly understand and support, but we insist on reasonable explanation of alternatives to save more trees in each lot. We understand that all trees cannot be saved, but it seems unreasonable to have to take down this many significant trees, many of which are over 100 to 150 years old. I'm not an architect, but with a quick brainstorm, one could think of a number of options to save more trees. If you look at the lot, most of the large trees are actually along the edges, not in the middle, as the applicant just stated, which could lead one to believe that there must be other options. They did not explore angling the house to shift the footprint, omitting basements, as they've clearly disagreed to do, making one or both with a single-car garage, getting a variance to make a duplex. Driveways in a different spot are made with permeable material. This is not the first time the applicant has taken out a significant tree for a driveway. Bridging roots, there's no evidence that they tried to explore that. Preserving more trees, not having to put in water catchment or catchment under the driveway with a permeable surface, or leave it 1 lot and build 1 house to shift it to the side to preserve more of the trees. They bought the property knowing the code and the distribution of the trees on the property. And lastly, mitigation. They did not provide a mitigation plan, and in my mind, this application is incomplete without a required element of the application. How are we to fully understand and weigh in on the long-term effects? The fact that the applicant only states they will provide a mitigation plan down the road or just pay into the tree fund shows little regard for the trees on this property or upholding the code. They would rather pay a fine than abide by the code set in place to preserve our significant community assets. Money alone does not repair the damage taking down this many trees will do. It will take 150 years or more to replace the trees and what they offer our community. We demand time to review and make comments on any mitigation plan that is proposed or lack thereof before the final decision is made. In closing, I respectfully beseech the committee to demand that the decision be overturned and these 2 permits be denied. These are significant, healthy trees and the only stand in many blocks. They are important features and assets to our neighborhood. This lot is not flat. The neighbor's redwood is at great risk. Removing these trees will drastically change the skyline. They are cutting much more than 50% of the stand, and alternatives must be explored besides just one option. Please think of the cumulative impact of all the permits that have been issued, what that has done to the tree canopy. Just walking around the neighborhood, you can see the difference. The city now claims to not have enough money to do another canopy survey. The last one was done in 2019. This is of great concern. Since 2016, in first edition in Forest Hills alone, 212 trees have been approved and taken down, with 11 more, including the 9 in question tonight, that have been approved in the last month, bringing the total to 223. In that same time frame, 8 trees have been denied by permits. Doing this math made me absolutely sick to the core of my soul. How could we let this happen? I hope you let these numbers resonate with you as you make your decision tonight. Thank you.
Are there any questions for Jill? Randy?
Oh, thank you. I understood you to say that the neighborhood takes the position that reasonable alternatives to this proposed plan exist but haven't been thoroughly explored. Could you elaborate on what those reasonable alternatives are that the neighborhood association believes have not been adequately explored? And thank you for your testimony.
Yeah, thank you very much. So David Rudowitz, whose letter you were reading from before, is part of the neighborhood association. Those were some of the things we discussed during our last meeting. As I mentioned in my testimony, I'm not an architect, but just a couple things that I could think of were turning the footprint to change those trees, flipping one of the footprints to retain more trees, not do basements, make a little bit smaller house. We all completely understand that development is going to happen anyway, but those are really significant trees. They're a stand, and only one design was ever presented, and the only thing that ever changed when the city asked them to show alternative designs was that they moved it. I think the arborist said 4 feet. There's lots of houses. I showed some examples there on the slide. There's houses all over the neighborhood. I mean, you can walk from one side of the neighborhood to the other and see 30 new homes that have made U-shapes or bridged roofs or done all sorts of different things to still build really big homes, but also save those trees. It seems like we should expect the applicant to do that and not just say, oh, your design doesn't work, okay, approved. That seems really appalling to me.
Any other questions? Okay, would you like to do your own testimony now?
And if I just let my voice take a break and go after a couple other folks, that'd be great.
That's
Thanks.
fine. John Dunn?
Thank you very much and good evening. My name is John Dunn and I live at 556 7th Street in First Edition. I'm here to provide comments in opposition to the proposed tree removal on 8th Street, lots 529 and 541. The arborist report commissioned by Renaissance Homes suggests that the condition of the stand of Douglas firs is fair. Note the emphasis on fair and not poor. While C or fair is not a great grade, it certainly is a passing grade, as indicated in the code. These are healthy trees. All these trees appear to any observer, anybody, and I'm sorry that many of you haven't had a chance to look, they're healthy, they're green. Thank you very much for listening to me.
Thank you. Can we, let's hold our applause. Any questions for Mr. Dunn? Okay, thank you.
Thank you very much.
Do you have a question? Hold on.
Mr. Dunn, would you come back and speak for just a minute about the coastal redwood and what assessment you think has not been done in terms of the potential impact if this grove is removed? And if you just comment about that. You said nothing has been done as far as you know.
Nothing other than what I have done. Honnold is the arborist that I use to make sure that that redwood tree is protected and cared for. So recently, Honnold, his group, did a very nice trimming, taking out some dead limbs of the redwood. They also did a cable at the top at a reasonable cost to me, but that's fair, right? But he also pointed out, wow, when those trees go down, the wind throw effect on your redwood is going to be substantive. I mean, I don't know what else to say other than we heard this as well from the arborist tonight, Ms. Gersh, I think it is, who said the same thing. It will be. And then the roots will spread, and they do, across that alley into that lot. They have to. Now, I don't know that. I haven't dug over there. I don't trespass anybody's lot, and I certainly wouldn't do that to Mr. Sebastian's lots. That would be wrong. So there's a lot of unknowns that no one has engaged me in terms of the impact on my redwood. It's a beautiful tree. Thank you.
Well, thank you.
Okay, thank you. Again, hold your applause, please. Okay. Next person is Louis Ekman. Luis.
Can you hear me?
Yes.
Okay.
1 second. Are we having two or one
I will explain.
I am Stuart Ekman. When we signed in, we did request that we speak together.
I'm just questioning so we know time-wise.
Well, each person has 5 minutes.
Okay.
Not two together at 10. So I would ask for one person to go ahead and testify, then the other person can testify.
You go first.
Okay. First of all, wow, I'm floored. According to Mr. Sebastian, there were an excessive number of comments. I've held positions like yours at the municipal level and the state level, and to me, when someone has an opinion that they want to convey, it's important for me to hear. So I'll go back to my comments. I'm Stuart Ekman. My wife Lois and I are first edition residents, attracted to the community for, among other things, what the 2020 Tree Summit aptly called Lake Oswego, City of Trees. We purchased a house adjacent to the stand of trees in question, and when the property was sold for development, we were comforted that the city code prohibits more than 50% of a stand of trees from being removed for development. We were comforted by the fact that according to city code, trees cannot be removed when doing so would create a significant change in the skyline. And along the same lines, we should have been comforted that the developer who purchased the properties in questions claimed on their LinkedIn site that they, and this is a quote, broke new ground by committing to build all our homes green, end of quote, and as a result, quote, have become nationally recognized as a leader in the green building movement, end of quote. So what does that mean? According to the World Green Building Council, a green building is a building that in its design, construction, or operation reduces or eliminates negative impacts and can create positive impacts on our climate and natural environment, including consideration of the environment in design, construction, and operation." End of quote. Yet, when this developer was confronted by a request to adapt a design to the lot, their response to the Fan Forest Hills Neighborhood Association is that, and this is a quote, "Our stance is, as the property owner, we are allowed to develop the property as permitted in the zone as the code allows, and we do not believe it is a reasonable request to alter the design or reduce the footprint and not fully develop the site based on the opinions of others." So, is this builder's comment on their own website a true commitment to green building, or is it just marketing hype? It seems like this isn't a case of a clear commitment to green building, but instead a case of clear-cutting all things green. This builder states on their website that they are extremely proud that our team designs and develops every house plan that we build. And they say our team has developed a catalog of hundreds of plans from which we have carefully selected a collection to meet the needs of our customers. Then they go on to say, if the plans offered in our collection do not meet your specific needs or requirements, Renaissance offers design services to refine or create a house plan suited for you. With hundreds of existing plans, a design team can create custom designs and a commitment, at least on paper, to green building. And I submit that this builder could go beyond mirror images of one of their stock designs and create 2 house designs that could achieve a balance between the environment and their proposed development. And at this point, I'm going to turn it over to my wife, Lois.
Okay. Thank you. My name is Lois Ekman. I live at 741 B Avenue with my husband, Stuart. The developer was asked by the city about leaving a tree near the proposed driveway along the alley. They responded in effect that leaving a single tree from the stand wasn't viable because doing so would expose it too much to wind. And that's exactly what would happen to our neighbor John's tree at the far end. By the way, the initial plan submitted claimed that these lots were flat, and I know that Jill covered that in her statement for the neighborhood association. They are not. There's a 7-foot difference between high and low points on one lot and an 8-foot difference on the other. The gravel pit mandated to deal with the wet weather was proposed for the higher end of the lot, which makes no sense. It's like having a drain in a bathtub that's below the water, that's above the water level. It just doesn't work. We are concerned about excess drainage runoff into the yard. And if Jill had been able to make that video work, you would have seen that presented tonight. Other builders, as Jill has shown, have used creativity to balance tree retention and the desire to incorporate a basement. Near the corner of B and 8th, a builder managed to bridge the root structure of a large tree, which is very close to the house, quite literally building a basement around these roots. So they had wanted to build the basement on the whole footprint. They were only allowed to build half of that in order to protect the tree roots. That tree is healthy, that tree is standing, and it's a large house. So it was a win-win situation. We share these concerns with quite a few of our neighbors. These tree removal applications have galvanized the community in their response. Well over 100 residents have shared similar concerns, more than any other tree application in the institutional memory of the neighborhood association. This is not a case of resistance to development. You know, we like progress. It is asking the city of Lake Oswego, asking you, the DRC, to ensure development is done according to the code without adverse effects to nearby trees, nearby properties, and the First Edition skyline. This is not a case of the developer against environmentalists. It's a case of following the city's code. That is what we were asking. And before I complete my comments, I would like to point out something I haven't heard anyone say. In terms of, yes, the design fits the footprint in the building envelope, but does Renaissance Homes really need to put two 4,000 square foot properties on those two lots? If you decrease the size, you could decrease the footprint and save more trees. I've not heard anyone say that. I can tell you that in our immediate neighborhood, there's no house that's anywhere near 4,000 square feet. Do they really need to do that in order to make a profit? It's ridiculous. Anyway, I appreciate the attention of the DRC, and that's the end of my comments.
Thank you all.
Thank you. Any questions? Good. Thank you. Mark Seabright.
Hello, my name is Mark Seabright. I live at 782 8th Street. I commented on both rounds of the permits for both addresses, and I'm opposed to the permit applications. Most of my comments are a bit irrelevant based on what other people have already said, so I'll just make a short point. I'm a retired business professor, and I've written and taken classes which focus on how to assess the economic value of economic resources. I'm not a lawyer, and I don't have any understanding of the legal arguments about the subjectivity of aesthetic standards, but there's substantial literature in economics on establishing the value of intangibles. This perspective suggests both that you can put an economic value on such intangibles, but also that it's the only way to make a rational decision involving trade-offs. One of the takeaways from this research on valuing economic resources is that their aesthetic value is often overlooked or downplayed. For example, and this is really a major study locally, of Mount Hood found that its greatest value is aesthetic, more than either recreational or ecological benefits. Obviously, new development can increase adjacent property values in the tax base. However, in this case, it also has aesthetic and environmental costs. My concern is that underestimating the value of the latter would result in a greater loss of value than the benefit of the new development. You know, most of my comments others have already talked about, in that I think what's especially bothersome about the current situation is that other options, ones that could find a balance between the costs and benefits involved, have not been adequately explored. You know, the other aspect of this is really the short term versus the long term. Clearly, some of these alternatives might lead to lower short-term profits on the developer side, but when you compare that with the long-term view of the costs and benefits for everyone impacted, those losses would be insignificant compared to the relative benefit to the community. So I encourage you to explore other options of the developer fundamentally. Thank you.
Thank you. Peter Toll.
Hello. I want to thank you for your service. I've been in that seat, very similar seats in other communities, and I appreciate everything that goes into it. It's a lot of time, a lot of effort, a lot of thought. I'm Peter Toll. I live at 639 7th Street, which is about a block and a half away from the property. You're hearing some carefully crafted arguments tonight from some sharp legal minds. Their words reveal the flaws in the mundane and complicated city codes. If this were simple, we'd all be having a fun time somewhere. We know the city is compelled to examine the trees on every property when a developer puts forth their plans. Do the trees impact the canopy? Of course. Are they beneficial to the neighborhood? Again, of course. Do older trees have a place in our community when a developer feels they hinder a building and development scheme? The answer, apparently, is they're in the way. 12 trees, 3 left? The answer is simple. If most trees are in the developer's way, there it goes. If the roots are in the way, again, there it goes. The developer couldn't write a better code, I've been told. I'm not an expert. The rules are stacked against the trees and their beneficial impact on everyone who lives here. You saw over 200 trees gone in that neighborhood in the past 5 years. I'll spare you the litany of the environmental issues because according to the code, that's a sort of. Not yes or no, it's not black and white. I understand that. Should every tree be allowed to stand? Of course not. Should developers be allowed to continue their process requiring removal of all the trees that they want to in their way? Of course not. 12, 3 survivors. Unfortunately, the code doesn't seem to offer much middle ground. I'm not an expert in it at all. But in cases they've seen like this in the 8 years I've lived here, the trees seem to lose 9 out of 10 times. I think that's upside down myself. As an advisory body, you are compelled to follow a tree code which appears to serve one principal interest, and I'm going to say it, not the neighbors as much as the developers. Nature of the beast, I get it. We must consider the impact on the people and the neighborhood. We have to play by these rules. Do they serve the community well? I don't know. I urge you to take 2 important steps in your public service. 1, encourage elected city leaders, the ones you answer to ostensibly, to change the code. Make it more amenable to a balanced life here. 12-3. Not just press ahead. Ask those same elected leaders to declare a moratorium on any further tree destruction until they can craft new rules which will better meet the greater needs of the community instead of seeming to kowtow to the developers. I thank you for your service, I truly do, and I appreciate the time that you've given me this evening on this very important matter. Thank you.
Thank you. Suzanne Meckel.
I appreciate you all being here tonight. My name is Suzanne Meckel. I've lived in the First Edition since 1989, and my family has lived in Lake Oswego since the 40s. And I actually find it really hard to believe that Mr. Sebastian's family is from here, because people that are from this community in that long of time value our trees and know that that's what makes this community special. I actually had a long script written out. I think Jill has touched on a lot of things that I was going to talk about tonight. But one of the things I'm going to talk about in the code and why I think that these 2 applications should be denied is the city of Lake Oswego has documented problems with surface water in our neighborhood, and they have spent actually quite a bit of money trying to mitigate that. They spent $5.3 million on D Avenue to try to take care of surface water, which has been really ineffective. Like was mentioned before, these lots are sloped. And the replacement of the small home with two very large homes and the removal of the trees will definitely make more surface water issues in that area. The developer also has not looked at other alternatives, which to me would be hiring an architect with tree retention in mind, to use building methods for retaining trees. He could shrink the footprint of the homes and actually still make the same amount of money by using higher end materials and finishes. I think that houses would sell for the same amount as a big house if it just had, instead of MDF, actually had lumber used. He could reduce the basements as an option. We could calculate possibly the amount of water trees removed from the ground and shrink the water catchment or dry, what do I call it? The water chambers, I guess. And actually, those could be combined for both houses, I believe. They don't have to be separate necessarily. And actually, I was in the most recent ad hoc committee for the city of Lake Oswego, and we all reached out. Mike Buck reached out to the city council, and we've been asking for years to get the development and tree code so that they work together so that we didn't run into these problems, because it seems that it's been an issue for quite some time. And I think now is maybe a time to ask that again. Like I said, as a person who's lived in Lake Oswego for decades, I think it's really important before we change the whole landscape of the city and remove the assets to make this a desirable place to live. Anyway, I think, oh, and I had some photos here. These are some photos of homes that, this house right here, the developer of this property said they could not retain those trees. Those trees have been there for 10 years now, and it actually makes the house. There's several other, if you can move through the slides there. I'm not sure how to do it. Oh. Here's another examples of trees left with new houses. The house on the right-hand side is a new house with all these trees. And actually the one up there is Renaissance Homes. He didn't want to save that tree there, but we appealed that, and it's there, and it is now a heritage tree. Here's another house, several slides. It has trees all the way around it. Here's a house here with a tree right next to the driveway with a double garage. This is another house that has a bridge foundation for the garage to save a tree. This is on A Avenue. Here's that same house with all the trees all around it. The house next door to that, 2 large trees. See how close that is to the front of the house? Another one. And then the picture on the bottom there is I had a house built next to me in 2018, and I had a major I have the same slope to my property as these 2 lots, and this is water runoff from that new build. I don't think you can see these very well, but we had like 4 inches of standing water and mud in our garage after they built that home. You can see the water here running off the property into our property. It flooded our basement. And these are off of the city's website, a first edition in our water problem with the water running and pooling all over the neighborhood because of the large footprint homes that have been built and the tree removal.
Are you done?
I'm done.
Okay, thank you.
Thank you for your time.
Okay, next up is Terry Kramer.
Can you hear me okay?
Yep.
I'll keep my mask on then, thanks. Good evening, my name is Terry Kramer and I live at 505 8th Street next door to 529 8th, so just downhill from the property at issue. I'm not opposed to property development. I developed my own house and others should be able to develop theirs. But that said, the development must meet code and the applications before you do not. Let me start with a few facts. First, the property is not flat. The city's topographical map shows the elevation change in the properties down 8th Street and also sloping back to the alley. The elevation goes from 216 feet at the northwest corner of the applicant's property down to 206 feet at the southeast corner. That's an 8 to 10 feet elevation change down to my home and my neighbors, the Ekmans. 8 to 10 feet is not insignificant. Second, the USDA tells us that the typical medium-sized tree can intercept over 2,300 gallons of rainfall per year, and scientists have found that trees soak up so much rain that they reduce runoff by about 60%. The applicant wishes to remove 15 of 18 trees from its property, 9 of which are type 2. Third, per the city's website, the historic First Edition neighborhood of Lake Oswego suffers from chronic localized flooding. I will attest that I already get water pooling in my yard in different areas from rain. It's only going to get worse if this property is developed the way it's proposed. Lastly, per the EPSC manual, construction changes the characteristics of runoff, the creation of impervious surfaces, removal of plant cover, and compaction of soil by construction traffic allows less water to percolate into the soil and therefore increases the volume of runoff. Per the tree code, the applicant must show that removal of the trees, considering the proposed mitigation measures, will not have a significant impact, negative impact on flow of surface waters. In its application, Renaissance Home states that the 529 8th Street is nearly flat and that 541 site is flat. Both these statements are false. They also say that removal of the trees will not have a significant negative impact on flow of surface water. Given the facts I've just stated, this is just simply not true. In February, the city failed to challenge the applicant's false statements and found that the removal of trees will not have a significant negative impact on flow of surface water. Then in June, the city seems to hedge its bets about surface water damage, while at the same time issuing its finding that the applications meet the surface water criteria, specifically saying city staff must review and approve the proposed erosion control measures prior to issuance of the building permit and tree removal permit. Therefore, any erosion resulting from the removal of the trees is addressed as part of the construction of the dwelling. With the erosion control requirements of construction, staff finds that removal of the trees will not have a significant negative impact on erosion. They came to the same conclusion regarding stormwater management. Planning is saying that they'll let Renaissance remove the trees, and then the building department can require Renaissance to mitigate all the damage caused by the removal of the trees that were permitted by the city. It's saying that the trees, which absorb abundant amounts of water, can be removed, and significant amounts of impermeable surface from all the concrete required for the basements, driveways, patios, etc., can be added, and that somehow, after all of that insult to the land, somehow the building department's going to fix it by requiring mitigation. You cannot undo the damage once you remove the trees. I believe the tree code is independent of the building code and must be enforced regardless of whether or not the applicant plans to build. I hate that timer. Renaissance Homes has failed to meet its burden of proof. Significant disruption to the natural flow of water is clearly foreseeable, as is damage from diverted water to my property and my neighbors. The city and the DRC cannot turn a blind eye to the tree code. It must enforce the tree code to protect adjacent property. Also, with respect to the claim that there are no alternatives to build on that property, I was on the Renaissance Homes website this week. They have lovely two-story homes that would be beautiful on those lots that don't have basements and that would allow for saving some of the trees. So It's time for the city to enforce the tree code and deny the applications for 529 and 541 8th. Thank you. Questions?
Thank you. Yin Pham Basford, you're succeeding your time, is that correct? Okay, so then we move down to the next person, which would be Chris Waterbury.
Who is she ceding her time to?
She's succeeding her time to Melanie Anglin.
Thank you.
Chris Waterbury? Not here. Great, okay. Diana Bohm?
Hi. Hi, Randy. My name is Diana Boom. I live at 557 Evergreen Road in Lake Oswego. I'll make this quick. I believe that the neighborhood association and the previous speakers and the people who have submitted written testimony have shown that these are significant trees, and the tree code requires that the developer provide reasonable alternatives to taking out these trees, and I hope that you will support the appeal and require those reasonable alternatives. Thank you very much.
Thank you.
Welcome.
Melanie Anglin?
I appreciate you all being here. Can you hear me? My mask, okay. My name is Melanie Anglin. I have lived on 8th Street for 15 years. The applicant has made no real attempt to compromise. They have failed to meet the burden of proof that no reasonable alternative exists. Also, they wish to remove more than 50% of the stand of trees. Our tree code must be upheld and the application denied. As someone who lives across the street, I know firsthand how much losing these trees will change neighborhood character and aesthetic. This will drastically change the character of the street and the view out the front of my house as well as my yard, affecting cooling costs and property value. I do not understand, with the historic flood of opposition to the tree removal permits, why the applicant chose to submit almost the exact same plans. Instead of showing ingenuity and craftsmanship, they used the same stock design. With an outcry of opposition from the people actually affected, I question why any developer would be allowed to come in and not abide by our tree code. It has been unanimous that the feeling is that losing the stand of trees on 8th Street to an almost complete clear cut would be a significant loss to our community. We do not ask that properties not be developed. We absolutely understand that there will be development in our neighborhoods. We ask that the applicant take lead from other developers in our community who are building in a responsible and respectful manner. When a developer considers buying property, they must consider the rules in advance before purchasing. If there is a need to break the rules to fit their wants, they should pass on that property. It is time that our city planners stand with its neighbors' interests in mind and enforce the tree code. The applicant refused to do the work. They failed to meet the burden of proof. I would like to submit to you my burden of proof that alternatives do in fact exist. And I have a slide. That's not it. Okay. Whoops. Okay, whoops, they're all out of order. Although my son knows nothing about maps or architecture, I simply asked him to take a map of the property. And in using the same stock design footprint, I said, pretend you are playing a game of Tetris and see what you can come up with to save the trees that ring around the property. This is what my son came up with. I only helped him fill in the written details later. I believe that the western cedar at the top, which my son put up for removal there, I believe that the western cedar would be easy to save as well. It would give a thoughtful and qualified architect an opportunity to incorporate the beautiful cedar as an asset and not a hindrance. I spoke to a professional arborist. Although he was unavailable on the dates needed to help us for this hearing tonight, he strongly disagreed with the condition assessments made by Renaissance's arborist. He felt the report should be challenged. I asked, if not already a factor by the date of the hearing, that a third-party arborist who does not have a conflict of interest should be allowed to assess the condition of the trees, especially those marked poor. Later, I asked my son to split the homes again, and this is how that looks. Whoops. Out there. And that's the same square footage, and then opposed to Renaissance's design. Renaissance, a custom home builder, is not capable of what my son can come up with in 20 minutes, but instead has dug in its heels. I ask them to step up. I advocate forcing the applicant to actually provide proof of no reasonable alternatives, for my son has already proven that alternatives are possible. Renaissance Homes has the opportunity to do the right thing. They have the opportunity to not waste any more of the city's time and the money on appeals and put up a solid plan that shows quality, craftsmanship, compromise, and respect. You can feel a palpable shift when out talking to the neighbors, a line drawn in the sand. This is the property that is making us all stand together strong and say enough is enough. The historic wave of opposition to this tree removal permit application was gathered primarily in just 4.5 days. When the first tree removal permits were posted back in February, after so long isolated by COVID indoors, listening to the news constantly telling us over and over again that we are divided, we walked outside blurry-eyed, looking around, assessing the damages done to our city while we were indoors. What I hear again is enough to this unnecessary piffling of our trees. It was one of the first opportunities for neighbors to join outside together again and speak to one another face to face and remember that we, in fact, are not divided. We are neighbors and we are friends. I have met many neighbors that I did not know previously, and I have never been so proud to be part of this community. I stand with these new friends who have a very common vision of maintaining our tree city status. We will not back down. I do hope the professionals can come up with a compromise like my son was able to do in minutes. Our concerns are documented. Because the trees create a windbreak to the neighboring trees, their removal could cause unstable and dangerous trees or even death on neighboring properties. If this happens, we will be forced to take action. When there is flooding to neighboring properties, when our property values decrease, when our landscapes die, we already know that we will remain banded together strong in this fight. With an entire stand of trees gone, the casualties to the plant life and habitat to the properties would be vast, in all directions under the shade of those trees. Habitat thriving in that space would be decimated. As money goes into the pockets of developers, we should not have to clean up their mess out of our own pockets. This clear cut is irresponsible, disrespectful, and what the applicant may view as a slight inconvenience will affect our city for decades. Please save this significant stand of trees. Please help to save our diminishing tree canopy. Our tree code must be upheld, and not more than 50% of this stand of trees should be allowed to come down. The applicant must step up. Thank you for your time.
Thank you.
Thanks.
Okay. Jill, have you recovered? Come on up.
Again, for the record, Jill Shin. I live at 949 Cumberland, and this is my personal statement. I am Jill Cabral Shin. I'm now speaking personally as a concerned neighbor. As you can clearly see, I'm a mother. I also have a 3-year-old at home. My husband and I moved here because we wanted to raise our family in a unique and beautifully forested area, amidst all the benefits that provides. The devastation of our significant trees that we have seen in just 3 short years is staggering. Do you mind pulling that presentation up again? Yeah. Thanks. This devastation of our significant trees that we have seen in just 3 short years is staggering. Look at the far left compared to the far right. The loose adherence to application guidelines, frequent incomplete applications, and the countless exceptions to the tree code. How can we let this happen? The guidelines set in place to protect our significant community assets are clear and should be upheld by our city, who was chosen and appointed to represent the best interests of all of us, its citizens. There is a glaring lack of adherence to the code throughout this application. I implore you to deny it. First and foremost, regarding removal 55020801, 3 of the 9 trees are some of the biggest in the neighborhood, and they are certainly significant as the only stand for multiple blocks in multiple directions. They're also highly significant to neighbors in the immediate vicinity. If you live next to this lot, you would certainly think they were significant. In regard to erosion and surface water and windbreak, I think we can all agree that this lot is not flat. And if you all don't mind, since it wasn't working before, I can show this video that I took. Is that okay?
Was this video submitted in to
It
us?
was. This is it here. It just isn't going to play.
Okay, thank you.
See that? So clearly you can see that a very significant amount of water rushes down that street during any rainstorm, which, as we can all see over the last couple of weeks, is definitely more and more frequent. Again, I think we can all agree that there's a 10-foot slope from one side to the other, and that is an important consideration in erosion and stormwater mitigation. We can also all agree that John's tree, the redwood, which you see to the right on the first picture and to the left on the second picture, when all of those trees next to it are removed, will certainly be significantly impacted by wind throw. There's also a significant change in impermeable surface, which you can certainly see in that drawing there. You can see these trees from all across the neighborhood from well over 300 feet. Losing them will create a major gap in the skyline, and the applicant should not be able to state that there will not be a gap because they're taking down all the trees. This is also very clearly a stand. You can see that in any of these pictures, and this is part of the code. You cannot take down more than 50%, and I strongly, strongly urge you to please uphold this portion of the code. There are certainly alternatives to preserve that much of the stand. They insist on reasonable development, which we certainly understand and support, but we insist that reasonable explanation of alternatives to save more trees in each lot. We understand that all trees cannot be saved, but it seems unreasonable to take down this many trees. Again, they bought the property, knowing the tree code, knowing the distribution of the trees. There must be some other option that they can come up with. Again, in regards to mitigation, 550208, there is no mitigation plan. This application is incomplete and should be denied. Please think of the cumulative impact on all of the permits that have been issued and what that has done to the tree canopy. Again, you can see that here. Just walking in the neighborhood, you can see the change. I've seen that in just 3 years. I'm sure those of you who have lived here for 30 years or longer can certainly agree that that has changed quite a bit. Think of also the neighbors who will be directly affected by these trees being cut down. Lois and Stewart, who have paid over the years to help maintain these trees so they remain healthy and continue providing shade and beauty among countless other benefits. Terry, who loves all the diverse plants in her yard and counts these trees as part of her landscape. As they live downslope, Lois and Stuart and Terry will be greatly affected by any runoff and flooding as well. Or John, who responsibly maintains his redwood, which will now be at immense risk due to the loss of all of its neighbors. Or Melanie and her family, who live across the street and love looking out at all the beautiful trees. Again, imagine if you lived next door. What would losing these trees mean to you? It is your responsibility as a city to uphold the code, to make sure important community assets remain in our neighborhood for us and most certainly for our children. Don't you want your children to know the same Lake Oswego you do? I sure do. Again, this fact, since 2016, in first edition in Forest Hills alone, 212 trees have been approved and taken down, with 11 more, the 9 in question tonight as part of that, totaling 223, and 8 trees have been preserved. How could we let this happen? I hope you let that resonate with you tonight.
Okay, thank you. Next up, Nick Lesage.
Thank you very much to the commission. My name is Nick Lesage. I submitted a letter to this commission regarding some issues I take with these significant tree standards and the manner in which the planning staff applied them. I will not speak to those further here, as the letter speaks for itself, and I acknowledge that several of my marks tonight will be outside the scope of this commission's purview and may be better suited for a policy discussion. I beg the commission's pardon on this. But I hope to add another community perspective to this conversation, one of a prospective homebuyer in our community. I grew up in First Edition. I was raised at 523 9th Street, which is well within view of this stand. I was raised there. I was educated there at Forest Hills Elementary School. I would like someday to own a home in Lake Oswego. It is my community. As a future home buyer, I have a vested interest in the expansion of the housing supply, and I am disappointed by applicant's commentary that seemed to suggest he was doing me a favor with his actions. I would like to live in a community that has a rich abundance of nature, a natural skyline, and that instills in its residents a respect for the environment in which they live. I remember my wonderment and awe at growing up in a living forest, running through trees with my father, 5 massive Douglas firs in our backyard, many of which were very close to the house, walking through the neighborhood with school friends and gazing at the canopies created for me a strong appreciation, not just for the environment in which I live, but also in my community and its beauty. Applicant's remarks were long on posturing and short on substance. There is a rich irony in applicant's attempt to frame removal of trees as necessary to expand housing supply to make homes more readily available and solve a, quote, housing crisis, unquote, when almost certainly these homes would be in a price range that are far out of reach for the vast majority of new homeowners. If applicant is serious about creating more housing for people such as myself who are searching for homes, I would encourage applicant to construct smaller, more modest homes that not only respect the landscape around them with a smaller footprint, but are actually more affordable for those looking to buy. I am not convinced that this is about the housing supply more broadly, so much as it is about applicant's pocketbook. Applicant's point that these trees need to be cleared for all housing is well taken, that trees must be cleared for housing generally. I take and accept this. Yet it poses a fallacious and false dilemma with the undertone that we can either have trees in our communities or we can have houses. This is false. This is a logical fallacy to its core. Increasing supply does not mean building enormous new houses. I grew up in a property with 5 enormous Douglas fir trees in First Edition. I grant that some trees were inevitably removed to build this home, but also can promise you that many were saved by careful design, thoughtful design, creating a wonderful home to grow up in, surrounded by many trees. I work in law and in policy, and I understand property rights. I am not here to try and remove those from anybody, but I am encouraging developers to be more than just developers. I am encouraging them to be good, thoughtful neighbors. I would like to thank the commission very much for their time tonight and for hearing me.
Thank you. Is there anybody else that wishes to testify that we didn't put their name in? Okay, seeing none, we'll move on to applicant's rebuttal. A 5-minute break. That's fine. Be back in 5 minutes. So that would be.
The Lord Almighty.
Okay.
Kat, do you mind pulling that?
Please take your seats. Applicant's rebuttal.
Yes, again, for the record, Jamie Housley, counsel for Renaissance. I wanted to bring up this exhibit here and talk about it in light of the voluminous testimony we heard this evening. Again, the dashed lines in the middle of the lots show what the clear and objective lot standards would be for placing a house on these lots in the city of Lake Oswego. And the X marks where the trees are located, with the circles representing their sort of impact and potential like root zone. So you can see where they're located. It's a total challenge to try to design buildings that will meet the city code to be placed on these lots. And I bring this up because in the professional judgment of the city of Lake Oswego staff, we have met the requirements of the city code for the removal of the trees in this case, and they've conditioned that as such. All the testimony that we heard this evening, talking about aesthetics of neighborhoods, talking about reasonable alternatives, talking about cumulative effects, neighborhood aesthetics, important features, drastically changing the characteristics, economic values, enjoying the trees as I'm walking down the neighborhood. Again, those are all subjective, value-laden judgments that others are bringing into this application. What is clear, again, is that this application meets the professional judgment of the city of Lake Oswego staff for the removal of these trees under that condition. And again, in the alternative, the city of Lake Oswego's tree ordinances do not meet Oregon's needed housing statute and requirements there because they are not clear and objective. As you heard, all the testimony again and again, characteristics, aesthetics, these are all people's different values, and reasonable minds will differ. The obligation here is to deny the appeal and approve this project moving forward. And with that, I thank you for your time.
Okay, is there any questions? Okay. Evan?
You may proceed to deliberation, Mr. Chair.
Okay. Okay, thank you. Randy, what are your thoughts?
Can we ask questions of staff at this point, or is our questioning time over as part of our deliberations?
We can ask questions of staff.
As part of our deliberations?
Yes, yeah.
So there was significant testimony about Mr. Dunn's coastal redwood tree. Am I correct that for purposes of considering this application, the impact of tree removal on the lots in the application is limited to those lots? We don't consider the impact on adjacent lots, trees of the removal?
We do. That is, it looks at adjacent trees. It doesn't say it has to be on the lot or off the lot. But the finding from the applicant's arborist, and which was concurred to by the city arborist in her review of that arborist report, was that they talked about the impacts just being limited to these cluster of close trees on both of these lots. The redwood, are you able to point to where it is on the site?
I don't have the thing.
Well, it's in the upper left or right-hand corner across the alley. So it is not as in close proximity. It's a taller tree, as was shown in the photograph. So it does have some wind impacts that it has. It's not shielded because it's a taller tree. It's a little bit more open grown. But that was the findings of, as far as any significant evidence in the record, it would be the applicant's arborist, and then there was a review by the city arborist who concurred.
So if I'm understanding correctly, the applicant's arborist and the city arborist reached the conclusion that there would be insufficient deleterious impact on this coastal redwood tree to interfere with approval of the application?
Yeah, they did not find that there would be no impact. They find that there would not be a significant negative impact on the wind protection of that tree.
You just refer to the applicant, you'd refer to the evidence in the record then?
That's right.
Yeah.
There was some discussion about the lots being characterized as flat, and some testimony was that there was a significant 7 to 8 foot drop relating to, I think, surface water runoff. Does that change the analysis of the staff about the suitability of the application?
The applicant is required to meet the stormwater code, which every applicant that has any impervious area that's over 1,000 square feet has to meet that standard. They are removing the trees in order to build on these lots, which is going to have a significant amount of impervious area that wasn't there before. The applicant, the staff has reviewed their stormwater plan, which they're required to maintain a stormwater system on their site, and found that it does comply with the code. That's the finding.
Thank you. Those are my questions. I'd be interested in other commissioners' comments.
Please, this is our time to talk. You've had yours.
A question for the staff. Could you review for me, there was a lot of testimony about the 50% cutoff of a stand. Can you review for me how that difference of opinion is mediated by the code? I mean, clearly this is more than, if this is a stand.
Yes.
This is more than 50% of
that
the
on
stand.
both lots, the removal is greater than 50% of the stand of trees. What the standard says is that Criterion 55.02.0803 requires that the removal of the tree will not have a significant negative impact on the character or aesthetics of the neighborhood. This standard is met when the removal of the trees does not involve, there's a number of other criteria, and one of them is greater than 50% of a stand of trees. And then below that, it says exceptions. This subsection 3 is not applicable when, and there's two criteria, exceptions that are allowed. And exception B says, alternatives to the tree removal have been considered and no reasonable alternative exists to allow the property to be used as permitted in the zone. In making this determination, the city may consider alternative site plans or placement of structures or alternate landscaping plans that would lessen the impact on trees so long as the alternatives continue to comply with other provisions of this code. So it doesn't prohibit the removal of more than 50% of the stand. It just requires that if you do, then you're required to meet one of the exception criteria.
Thank you.
Anybody else? Craig? Mike?
You know, I just listening to both sides, development something that, you know, home ownership, ability to provide more homes is a critical part of the city. On the other hand, there's a tree code that has a purpose. And I think the ability to provide additional design options is something that really is on my mind, that if I look at the plan and the ability to, whether it's square up the house and move it one way or the other to save a couple of these trees, you know, certainly that's an option that I think is possible. So that's my thoughts at this point.
Okay, Dwight?
Yeah, I hear all these discussions about whether the tree code is applicable and whether the tree code is objective, and I think that I'm going to have to make my decision on the basis of the existing tree code and my understanding of that tree code. And when I look at the description of a significant tree or a significant grove of trees, it's very clear to me that this is a significant grove and a significant tree. In fact, before the meeting started, I realized you can see those trees from this room. But as we just heard from staff, there is a very clear exception, which is there is no reasonable alternative. And I think staff has taken an objective look at whether there are reasonable alternatives and have concluded no, that there is no reasonable alternative. And if we're going to follow the code, then I think that we have to approve this.
Sure.
I've been on the DRC for a while now, and we're charged with applying the code. And I was thinking tonight that we're seeing a lot of tree permit, you know, applications, appeals. And what has struck me is that the community, when it comes to cutting down a tree, they show up at the DRC and voice their opinion. And I was thinking, the members of the community that are upset about the tree code and cutting trees down should show up and tell their elected officials what their opinion is about the tree code. Because as a commissioner, my job is to apply the tree code. Now, I don't agree with Mr. Housley that, you know, the city's tree code is unenforceable. I just don't agree with him. I haven't had a chance to look at review the cases, but as I said before, I'd be surprised, and maybe the city attorney can, you know, give an opinion. But this is my own personal opinion, and this is from my experience, and this is what I struggle with our tree code, is that developers are following the rules. They look at the code and they say, this is what the code says, and while we didn't have it in our packet, and we're charged with like reviewing evidence that we have in front of us. I was wondering, because I do real estate and land use, I was looking at, I was like, I wonder what the FAR is on this, you know, on the property. And just eyeballing it, it looked to me that this is a 6,000 square foot lot, and it looks like there's like a 4,000 foot square, you know, footprint. And so I was thinking, maybe it's designed that way because it's single level for older folks who can afford whatever property is going to cost. Because I also figured out what the developer paid to buy the dirt. And I'm starting to think, oh, that's the reason that they probably designed it that way. That's a long-winded answer to say my struggle is that the way that the tree code is written is that if you're an individual, this is my opinion, if you're an individual property owner and you want to take 1 or 2 trees, it's really tough. You're just not going to be able to, you know, I remember the judge that, you know, the branches and the pine cones and everything was falling on his deck. Poor guy he finally had to appeal to the city council, you know. So if you're an individual property owner, you're stuck. You're not going to get past this tree code. If you're a developer, because of the exception of, you know, no reasonable alternatives and also, you can take the chainsaw and you can cut trees down. And I mentioned tonight, I was, you know, I'm struggling with the idea that you use an invasive tree permit to take down a couple of trees, and then as you kind of just keep, you know, it's like little bites, you know, you start taking invasive trees out and then you take other trees down, and then a tree that you probably could save, well, you can't keep it now because of the wind throw. And I'm not a tree guy, but I was like, that caused me a little bit of concern that, you know, I was thinking, hey, that's a great idea. We'll cut the invasives down and then we'll use the wind throw and another tree's a goner. So that's a long-winded answer to say, I mean, if we're applying the tree code and the developer follows the rules, then in my opinion, I have to apply it and say, you know what? The developer has the ability to you know, cut the trees down. And if the community is so upset about, you know, cutting more and more and more trees, 200 trees or whatever it is, we're not elected officials. We're appointed by the folks that they should be talking to say, you know what? We're upset about 200 and whatever trees that have been cut down in our community and the canopy, and I get all that, but it's like, well, they're in the wrong venue. You know, if you're upset about it, go to your elected officials and tell them about it. Otherwise, we're going to keep seeing these applications in which the developer walks in with their attorney and says, hey, you know what? I followed the rules and I follow what your code says. Give me my permit to cut the trees down. And my perception is okay, because my job is to apply the tree code. So that's my 5 minutes, I guess, on this application. So.
Yeah, I think we heard, was it Peter Toll said the codes are stacked against the trees, and I think that that's the reality we're dealing with.
Our job is to enforce the code.
That's
right. Excuse me. You're out of order, please. You're out of order. Thank you. So is there a motion?
I did just have another comment,
Sure.
if I could, having listened to everyone. I do agree with Commissioner Smith's analytical approach. Our charge is to apply the criteria and the code. And I think as discussed, listening to the witnesses, listening to the applicant and the staff, I am persuaded that this application does comply with the code we've been handed. And I particularly read with interest former Commissioner Teresa Kohlhoff's June 10th, 2022 email testimony, and do generally agree with her analytical approach as well. We're talking about the exploration of reasonable alternatives for development as permitted in the zone. And I think that this removal of the trees will be a tremendous loss to the enjoyment of others in the community, but I think it's within the rights of the property owner to develop the property as applied and as the staff has analyzed it. So I'll be voting not to approve the appeal and in favor of the application.
Okay. I would just like to say that I've been on this for 7 years. The most difficult thing we do is type 2 tree permits. I am constantly would like to let the citizens of Lake Oswego know that the staff in our department, Jessica's and Evan's, do their very best to lay out a case for us that is by the book and with no favoritism, and they do a really good job. But with Kirk, like he mentions, you know, we oversee how staff sees if the rules were followed. That's our job. We're volunteers. Maybe you should volunteer. So with that said, I think staff's done a really good job, and I will vote to approve the applications, if there's a motion.
I'll make a motion. Should it be, Evan, should it be to deny the appeal, or should it be to accept the?
Excuse me, Dwight, we need to vote on each one separately.
Oh, okay.
We heard them together.
Yeah.
Right.
You could just say.
I just wanted to know whether I'm denying the appeal or whether I'm accepting the
Well,
proposal.
as I said, the tree code uses the term appeal and a request for hearing. This is the first evidentiary hearing, so, and it's a tentative decision with an evidentiary hearing now. To me, it's, you would move to grant the tree removal permit. That's the ultimate question here. If you want to say deny the appeal and grant the tree removal permit, fine.
I will move that we grant the request for tree removal AP 2203, and I'll just do one at a time. And consistent with the recommendations of staff and the staff conditions.
Is there a second?
Second.
Thank you. Kat, could you poll us?
Shearer?
Yes.
Arthur?
Yes.
Smith?
Yes.
Silent?
No.
Berardi?
No.
Poinsett?
Yes.
Thangri?
Yes.
Passes?
5-2.
I'll make a second motion to grant the application for removal, AP 2204. And that again is with the consistency with the recommendations of staff and the conditions that they have proposed.
Is there a second?
Second.
Kat?
Shearer,
Yes.
Arthur,
Yes.
Smith,
Yes.
Stylen,
No.
Berardi,
No.
Poinsett,
Yes.
Sangre.
Yes.
Motion passes. Okay,
writ-
our next.
That's
go
a
ahead.
tentative decision. A written findings be brought back to the commission on Wednesday, July the 6th.
Jessica, do we have any other business?
Yes, we do. I'm actually sad to say that there's a couple of DRC members who will not be continuing on in their terms. They have decided, as you know, that we had 3 members who had their terms come up this year, and they are still in the process of filling in the positions, so I don't have any update on who's been appointed, but 2 of the members did decide not to reapply, and those are Commissioners Berardi and Commissioner Stylen. And I just wanted to take a few moments to thank them both for their volunteer service here on this commission and to the city. And we really appreciate.
If you could take it outside, that'd be great. We still have business going on.
So again, sorry, I lost my train of thought, but just really wanted to express our appreciation for your service. You both served 1 full term. Sorry about that. We do have some distinguished service awards that are I'm presenting on behalf of the mayor and the city manager that we'd like to present to you. So Commissioner Berardi, thank you
Great.
so much. I really appreciate your service.
Very good.
If I may, I'd like to thank all of the staff for a wonderful 3 years. I really appreciate everything you've done and shown me. Thank you.
Absolutely. And I will have an update once we know who has been appointed to fill the vacancies. We do have a meeting on July 6th. Just a reminder that July 4th is a holiday, so we'll be meeting on the Wednesday, 7 p.m. normal time. We have 1 item on the schedule, and I believe it is the Reseek Park application. We also have an item coming up on July 18th. And we have another item for the 2nd meeting in August. There's a possibility we will have an item for the 1st meeting in August, but that hasn't been confirmed yet. So we do have a pretty full schedule coming up the next couple months.
So I won't be here on July 6th because my daughter is having my granddaughter, so I will not be here.
Well, that's, you are excused.
Thank you.
Is anybody else planning to be out? Because we're not certain that the 2 members who will be appointed will be ready on July 6th, so will anyone else be out on that day?
I'm not sure that I'll be here.
I'll be here.
I'll be here.
Okay, so how many does that make? 5? We need 4. 1, 2, 3. Here, I'm seeing 1, 2, 3.
No, I think we'll have.
Somebody call in?
Yeah. Okay, well, let's, Chair Shearer, we can talk
I'll
offline,
talk.
and we will do our best. It's possible that we can get the new DRC members, get their orientation. I mean, they are eligible to.
They can hear the case. I'm thinking about approving the findings.
Oh, approving the findings.
Yeah. Well, let's see, if we have, well, no, I take that back. I mean, if the new people are here, so that would make 5. Those 2 people are not eligible to vote, so it would take a majority of those present eligible to vote, and I think we have those, so, okay.
Evan, if you'll recall, a month ago or so, I connected telephonically, which I know is an awkward thing. I did so because it was necessary for a quorum.
Yeah, well, it's,
Can we do that with the meeting on July 6th?
Well, I just got to see.
yeah, you have to see, if
I'll
you
get back to
can,
you.
great.
Yeah, well, let me
Obviously,
get back to it.
you can attend that way.
I got it.
But anyway, it's, as long as we get two news, as long as they attend, we're fine. Okay.
Okay. Anything else? Okay, we're adjourned.